approval of the minutes and then your preliminary remarks.
Yeah. Okay. So first, before that, before we recognize our Deputy Speaker for his sponsorship speeches on the two resolutions, we would like to therefore seek a motion to approve the minutes of the previous meeting.
Mr. Chair, I move to approve the minutes of the previous meeting. So move, Mr.
It's
Chair.
been moved and
Second motion, Mr.
seconded
Chair.
that we approve the minutes of the previous meeting. And we have a short preliminary statement by the chairman. The need for public discourse is the heart of any vital legislation and policy recommendation. This is a crucial part of the legislative process as it shows transparency, accountability, and civic engagement. These are what the Committee on Constitutional Amendments and this chamber uphold under the principle of participatory democracy. Welcome to the second regular meeting and public consultation of the committee. The consultation consists of two sessions, one in the morning, this is the session now, and one in the afternoon. We thank you all for your presence and participation, especially to our esteemed resource persons and guests. We value your personal views, expert opinions, and the positions of the different organizations, both from the private and the public sectors. We will start by first hearing the sponsorship of the two measures filed by 22 principal authors led by Deputy Speaker Ronaldo Puno, House Resolution number 460 and House Bill number 5870. Thereafter, we shall proceed with a public hearing or public consultation proper. The committee has invited representatives from different sectors, a mix of the young blood and the more experienced ones. They are experts in their different fields like business, the economy, governance, social science, law, and the Constitution. To provide clarity and structure, the resource persons will be guided with the following questions. 1. Are you in favor of amending or revising the 1987 Constitution? If yes, what mode would you prefer? Through Congress acting as a constituent assembly or through a constitutional convention? If no, why not? And the third will be, what specific amendments would you want to propose, if any? It is our objective that through this consultative gathering, the pros and cons of amending the Constitution will be clear and will help our citizens to be informed and involved in all the phases involving the highest law of the land. And equally important is that the committee's decision will be inclusive and representative of the interests of the Filipino people. May God bless the Philippines. May I now acknowledge Deputy Speaker Ronaldo Puno for his sponsorship speech on House Resolution 460 and House Bill number 5870.
Good morning, Mr. Chairman. It's a privilege to be here before this committee and, of course, our resource persons to present our ideas on the possible amendments to our Constitution. The Philippine Constitution is the supreme and fundamental law of the land, establishing the framework of government, defining the rights of its citizens, and serving as the enduring expression of the sovereign will of the people. The 1987 Constitution was crafted during a period of democratic transition, and while it has provided stability for nearly 4 decades, changing times and evolving national priorities now call for a review and possible refinement of its provisions to make them more responsive to present and future needs. Over the years, historical experience and jurisprudential discourse have revealed that certain constitutional provisions, by reasons of ambiguities or imprecise language, have given rise to inconsistent interpretations, procedural uncertainties, and political controversies, thereby undermining sound governance and eroding public confidence in constitutional processes. The principal objective of constitutional amendments is to clarify these provisions, eliminate the possibility of conflicting interpretations, and thereby prevent future crises, enhance the clarity, stability, and credibility of the fundamental law. Constitutional reform must be undertaken in a manner that is democratic, transparent, and inclusive, ensuring that the process reflects the diverse voices and aspirations of the Filipino people. It is our belief, Mr. Chairman, that a constitutional convention composed of delegates elected by people from all regions of the country is the most credible and participatory mode of revising the Constitution, as it guarantees the independence from partisan interests and affirms the sovereignty of the people in shaping the nation's future. It is in this interest and purpose, Mr. Chairman, that I propose the consideration of House Resolution number 460. Thank you.
Thank you, the author, the distinguished Deputy Speaker, Ronnie Puno. Now we'd like to hear our Vice Chairman and author of one of the measures for his comments.
Thank you, Mr. Chair. On resolution of both houses number 1, as the proponent of RBH number 1, I speak not merely on the proposal of change, but on a matter that goes to the very heart of our sovereignty, economic future, and the destiny of our nation. Our Constitution is the fundamental covenant of our people. It expresses who we are, what we value, and how we intend to build our future. Yet as the world changes, as the new threats and opportunities emerge, and as the global order evolves, there arises a solemn duty to ensure that our charter remains responsive, relevant, and firmly anchored in the realities of time. It is in the spirit that I respectfully present this resolution to amend the provisions of the national territory and economic policies of the 1987 Constitution. The definition of our national territory is not simply a paragraph in our charter, but the backbone of our sovereignty, the compass of our foreign policy, and the legal foundation of our security. Yet Article 1 was drafted before the United Nations Convention on the Law of the Sea fully reshaped maritime sentiments, before the global community recognized archipelagic states in the modern legal terms, and long before the Philippines achieved the historic 2016 arbitral award that affirmed our sovereign rights in the West Philippine Sea. Today, we find ourselves navigating a complex geopolitical environment with a constitutional definition rooted in a world that no longer exists. Our national territory clause, while noble and well-intentioned, does not explicitly reflect our rights under UNCLOS, our entitlement to our exclusive economic zone and continental shelf, and our authority over archipelagic waters, and the full legal weight of the arbitral ruling in favor of the Philippines. Because of this, foreign powers continue to question our claims and to intrude upon waters that international law says are ours, and to cast doubt on the clarity of our sovereign rights. Part of the reason they find room to do so is the lack of constitutional precision. Our highest law must speak with certainty where others seek to sow confusion. By updating the national territory provision, we assert clearly, firmly, and unambiguously that the Philippines stands on the side of rule-based international order, that our Constitution, that the Philippines stands on the side of rule-based international order, and that our Constitution aligns with UNCLOS, and that our sovereign rights in the West Philippine Sea are not a matter of negotiation, but a matter of law. We owe this clarity not only to ourselves, but to every Filipino soldier, every Coast Guard officer, and every fisherman who braves the West Philippine Sea. They deserve a constitution that protects what they defend. At the same time, we must confront the realities of a rapidly transforming global economy. Our economic provisions were drafted at a time of deep national fear and fragility. Understandably, our framers sought to protect Filipino industries from perceived external threats. But today, the world has changed, and so must we. We are competing on a global economy defined by technological innovations, shifting supply chains, and unprecedented investment flows. Our ASEAN neighbors have aggressively modernized their economic frameworks, while we remain constrained by rigid constitutional limitations that prevent us from adapting to current realities. These restrictions have led to stagnating levels of foreign direct investment, underdeveloped industries, barriers to technology transfer, insufficient competition, and missed opportunities for higher value job creation. Amending the economic provision does not mean surrendering control of our patrimony. It means empowering the Filipino people, the Filipino worker, the Filipino innovator, the Filipino entrepreneur to compete on equal footing with the world. By allowing Congress to regulate foreign participation through ordinary legislations rather than constitutional rigidity, we create flexible, dynamic, and evidence-based policy environment that can evolve with time and circumstances. This is not a radical shift. It is a pragmatic and responsible modernization. Colleagues, the choice before us is profound but clear. We allow nation to be constrained by outdated constitutional language in a rapidly evolving world. Do we equip the Philippines with a charter capable of protecting our sovereignty, attracting investment, creating opportunities, and securing a rightful place in international community? This resolution is not about politics or partisanship. It is about nation building. It is about preserving our territorial integrity. It is about strengthening our economic foundation. It is about where every Filipino is freer, safer, and more prosperous. History will judge us not by comfort of our decision, but by their courage. The work ahead requires sober debate, humility, and unity of purpose. But our responsibility is clear: to craft a constitution that does not merely reflect who we were in 1987, but to craft a constitution that does not merely reflect, but we must become in the decades ahead. Let us seize this moment. Let us strengthen our national identity. Let us protect our sovereign rights. Let us open the doors of opportunity for our people. Mr. Chair, distinguished colleagues, I humbly ask for your support for this resolution, for our sovereignty, for our economic future, and for the generations of Filipinos who will inherit the nations we shape today. Maraming salamat po at mabuhay ang Pilipinas.
Thank you very much, Vice Chair Edo Garbin. Before we proceed, let me acknowledge the presence of Vice Chairperson, the representative of the 1st District of Misamis Oriental, the Honorable Jennifer Karen Lagbas. Welcome to the hearing. And now we would like to hear Congressman, our Representative Copilar, who will speak on behalf of the Honorable Richard Gomez on resolution of both houses number 3, resolution of both houses proposing amendments of the Philippines, particularly on Articles 12, 14, and 16 by the Honorable Richard Gomez. We now recognize Representative Marvic Copilar.
Thank you, Mr. Chair. Distinguished colleagues and guests, I rise today to sponsor a resolution of both houses number 3, proposing amendments to the restrictive economic provisions of the 1987 Constitution, particularly Article 12, 14, and 16. This measure introduces the phrase unless otherwise provided by law, into key economic section of our Constitution, granting Congress the flexibility to adjust the foreign participation rules to regular legislations, instead of being permanently constrained by constitutional texts written 38 years ago. Mr. Chair, the Constitution has always contemplated change. It provides mechanism for amendments precisely on our nation may adapt to the needs of each generation. Today, the global economy is far more dynamic, interconnected, and competitive. Our neighboring countries have opened themselves to investments that generate jobs and uplift local industries. Meanwhile, our Constitution restrictive provisions have limited opportunities, discourage investment, and slow down the economic progress that our people deserve. The mandate entrusted to our present leader is clear, and it is to pursue prosperity, advocate the common good, and bring freedom from poverty to the Filipino people. The World Bank projects that the Philippines will remain one of the fastest growing economies in Asia. However, to sustain this momentum and translate it into inclusive and shared prosperity, we must ensure that our policy enable rather than restrict investments. Resolution of both House number 3 does not automatically remove safeguards. It does not surrender our patrimony. It simply allows future Congress to define through legislation the appropriate level of foreign participation for industries such as public utilities, education, mass media, and always subject to national interests. In view of the foregoing, I respectfully ask my colleagues for their full support for the approval of resolution of both Houses number 3. Thank you, Mr. Chair.
Thank you, Representative Copilar. And now we will proceed to the comments of our resource persons. This will be the sequence in this morning's hearing. First, we will hear Chairman George Barcelon of the Philippine Chamber of Commerce and Industry, followed by Attorney Catarina Gabriel Cosalan, Legal Counsel, Philippine Stock Exchange. Next will be Mr. Christopher Ilagan, the Joint Foreign Chambers of Commerce, Co-Chair, Legislative Committee, American Chamber of Commerce. Then we have Ms. Mariel Angela Soriano of the Advocacy and Engagement Specialist of the Arrancada Philippines Project, American Chamber of Commerce of the Philippines. Then we will listen to Mr. Calixto Toti Chiquiamco, President, Foundation of Economic Freedom. And then we will go to Attorney representing the Dean of the UP College of Law, represented by Associate Dean Attorney Compañero Paulo Tamase and Attorney Oliver Reyes. And we also have with us from the government, Assistant Director Judith Gondra. Next is Ms. Janice Putanes. Director Gondra is from the DepDev. And also Ms. Janice Putanes is Supervising Economic Development Specialist of DepDev. And we also have Yusek Dominic Velasquez, Chief Economist of the Department of Finance. And we have Director Marina Elenita S. De Sasso, Chief Legal Affairs, Department of Finance. Okay, has everybody been called? Yeah, all of you. So you know now how we are going to go through with today's hearing. So we now call on the Honorable George T. Barcelon, PCCI Chairman.
Thank you very much, Honorable Congressman Rodriguez. It's very nice to be invited. I remember we had the privilege of inviting you one time to a open discussion on the proposal of constitutional change in PCCI. So our stance basically is concerned, supportive of this any changes that we think that would benefit our country. In the meantime, of course, we know we have more pressing issues
that has befallen our country. But nevertheless, to have such a forum to discuss this is very good, wherein the private sectors are looked into this. I remember taking away from what we discussed previously is that we are very open for changes that are economic provisions in nature. Because that's within our, what you call, coverage on the business sector side. Other than that, whether it be CONCON, Constitutional Assembly, I leave it to the wisdom to our legislator. Primarily, of course, you have to consider the financial capability, the timing, and that it will not disrupt in any way the normal operations of businesses and also for the legislator. We have seen in the past that the government in the past few administrations have been very proactive in allowing our country to be more attractive to foreign direct investments. In the past, we have a few laws that has been able to help us: the Public Service Act, the Retail Trade Liberalization, the Foreign Investment Act, the Konektadong Pilipino, and some of the other laws that really open up our country for foreign investments. But there's this sticking issue of why the foreign investors are not coming. Although we have provided, ample liberalization on investment. Now companies can invest in our power, in telecom. Okay? Of course, there's some restriction as far as agriculture. We still stand that we have to protect our sovereign rights as far as exploitation of natural resources and land ownership. Okay? Now let me go back to why our investment has not been as progressive as other ASEAN countries. We know very well now most of the investments are going to the countries like Vietnam. Okay. And I did check on the difference between their constitution and our constitution. We are a multi-party system. We have 3 branches of government, while Vietnam is a single party, very similar to China. So somehow that gives them a leverage of doing things faster. But not taking away from our system of government, we have also has a good track record as far as our PESA, Export Processing Zone. We have the opportunity of meeting a lot of foreign delegations that come to the Philippines, expressing their desire to invest in the Philippines. And just to share with you, most of them would like to be in PESA. The reason why is because of the ease of doing business. There's no contradiction as far as the interpretation of the laws. And first and foremost, really for us to attract more foreign investments, is the ease of doing business. And definitely on our part, I had the privilege of, in both administrations, the administration of President Duterte and President BBM, I've traveled with both presidents in their trips to foreign countries to attract foreign investments. And we always put our best foot forward. But we do have some real issues as far as the availability and affordability of our power. And we're quite lacking in that. And also our logistic cost is one of the highest. I cannot imagine how many kilometers of roads would have been built if not for what we're experiencing on the PWH scandal. Okay. So all of those comes into play as far as being able to attract foreign investment. Okay. So with that, Your Honor, we are here to hear whatever proposal that would really bring our country's economic development, that would provide inclusivity, okay, and fairness equitably we are very concerned that our economy is hollowing out because we don't have too much manufacturing. Okay? We are basically a consumer economy. We live off the remittances of our hardworking OFW, which is about $40 billion a year. Okay? In one of the, may I say, sunrise industry, of course, is the BPO. Okay? But that again, we are quite concerned with the disruptive technology of artificial intelligence. It's being talked about that if we do not catch up early, we may lose a lot of jobs in this sector. And what I'd like to end is that we really have to focus on our industry. For a country that is an agricultural base, we import a lot of food-related items. Just to share with you, our trade deficit with our ASEAN countries is about more than $40 billion. Ibig sabihin, yung dollar natin, we are buying our goods mostly from outside. So that by itself reduce our job opportunities. So that's one area that we're quite concerned. Now, on the side of, we have made a discussion on the education side. Okay? We're now, the education sector is still restricted to Filipinos. And maybe that can be looked into as far as higher education that are focused on medical, sciences, and mathematics. Okay? If we can learn from others, maybe on those certain educational discipline, we can be more liberal about it. So with that, I'm sharing my thoughts, and I hope that those things can be looked into in the discussion of changing our constitution. It's 38 years since the last major change. So we are all in agreement that it's about time that we tweak it a bit. Maraming salamat po. Thank you.
Thank you, Chairman Barcelon. Let me thank the PCCI for inviting me. The previous Congress, we approved in the House economic provisions, amending 6 economic provisions. But unfortunately, the Senate did not act on that. So we're back here to again find out what is the best mode. As you have said, you're very much interested in the economic provisions, and you give it to Congress to decide whether it should be by CONCON or CONAS. Thank you very much for your thoughts. Thank you, Chairman. Before we proceed, let me just acknowledge the Dean of the San Beda Graduate School of Law, the Reverend Father Ranilio C. Aquino. Thank you for coming, Father. So now we will proceed, and we would like to hear from Attorney Catarina Gabriel Cosalan of the Philippine Stock Exchange. The floor is yours, ma'am.
Good morning, Mr. Chair. Good morning, Your Honors. Thank you for inviting the Philippine Stock Exchange to this public consultation. The PSE fully supports the amendment of certain economic provisions of the 1987 Philippine Constitution, specifically the easing of restrictions on foreign participation in the following areas of investment, which are currently reserved for Philippine citizens and corporations. First is the exploration, development, and utilization of natural resources. Second is the operation of public utilities. Third is the operation and ownership of educational institutions. And fourth is the ownership and management of mass media institutions. The grant of authority to Congress to eliminate or at least lessen by law these barriers will pave the way in attracting more foreign direct investments into the Philippines. Your Honors, at this juncture, the PSE would like to emphasize that openness to foreign ownership is a key criterion that investors look at when rating the quality of a market. So index providers, or let's say investment research firms such as MSCI or Morgan Stanley Capital International and FTSE, Financial Times Stock Exchange, These index providers create benchmarks or standards for stock market performance. They provide investment decision support tools for investors. So these index providers, Your Honors, they have classification systems which categorize markets, in this case, the Philippine markets. And under these classification systems, there is market accessibility. And on the criteria under market accessibility, I will just mention three, which is relevant to our discussion today, Your Honors. Openness to foreign ownership, ease of capital inflows and outflows, and the third is incidence of foreign ownership restrictions. So these classification systems, Your Honors, are used by these index providers to construct indices. So, Your Honors, what are indices? These are statistical measures that track the performance of a certain market. In this case, again, the Philippine market. Also, these classification systems are used by these index providers to compare the different markets from one another. Your Honors, as to the mode of amending the 1987 Philippine Constitution, the Exchange fully supports the calling of a constitutional convention. With this, the PSE would like to recommend that House Bill number 3068 and House Bill number 5870 include a provision establishing a committee composed of representatives from various sectors which will guide the delegates accordingly on policy considerations. We suggest that these representatives should be experienced experts from the following sectors, among others: economics, finance, law, health, tourism, labor and migrant workers, agriculture and fisheries, transportation, science and technology. So for the kind consideration of this honorable committee, Your Honors, the Exchange will submit its position paper by next week. Thank you.
Thank you, and we would certainly study your proposals on, you are in favor of opening our markets, as the three indices would be very important
Yes,
for
Your Honor.
our economy and then the Philippine Stock Exchange. Thank you very much, and your attorney, Kosalan.
Thank you, Your Honor.
So we now proceed with Mr. President of the Canadian Chamber of Commerce in the Philippines. We have Mr. Christopher Ilagan. Please proceed.
Good morning, Honorable Chair. Good morning, Honorable Committee members. I have a prepared statement, and then I'll answer a couple of the other questions you had posed separately. So the Joint Foreign Chamber of Commerce of the Philippines strongly supports the amendment and or revision of the 1987 Philippine Constitution, specifically the removal of restrictive economic provisions. The Joint Foreign Chamber has consistently advocated for the reform or removal of foreign equity restrictions, as these restrictions are inflexible and outdated. The embedding of rigid economic provisions in the Constitution has deprived the government of the necessary flexibility to freely adjust to future changes in technology, meet requirements under international treaties, and capitalize on new economic opportunities. Moreover, the restrictive provisions reflect a nationalistic and protectionist spirit from the 1935 and 1973 constitutions, an approach that no longer aligns with today's globalized economic environment. With the Philippine economy integrated into the global economy and engaged in numerous free trade agreements, these old provisions no longer serve the country's best interests. These restrictions undermine the country's competitiveness. They contribute to lower investments, fewer jobs, poorer infrastructure, and less inclusive development. Major international organizations, including the World Bank and the OECD, consistently cite the Philippines as one of the most restrictive economies for foreign investment worldwide. The most direct and effective way to address this challenge is to remove these constitutional barriers entirely. Now, on the question on whether it's a constitutional convention or a constituent assembly, We prefer not to comment. We rely on the wisdom of our legislators in Congress to decide that. But in terms of the specific provisions, our intent is to submit a full-fledged position paper. But to the point of Honorable Copilar, right? The same sections that were raised in your speech earlier, 12, 14, and 16, are precisely the same ones that we would like to see changes to. Historically, we have taken the position of inserting where appropriate, unless otherwise provided by law. But if there is an opportunity actually to take a look and see if we can outright remove those sections, this may be the opportunity to do that, right? And so, we would invite the Congress to look into that. We will submit our position paper, and where we think it might be appropriate to actually just strike it out entirely. But we look forward to continuing engaging, and thank you so much for inviting us.
Thank you, Mr. Ilagan. So we would certainly value your statements and the position paper you're going to submit. That is from the Joint Foreign Chambers of Commerce of the Philippines. Now we go to Ms. Mariel Angela Soriano, also the Advocacy and Engagement Specialist of Arrancada Philippines Project and the American Chamber of Commerce of the Philippines. Yes, Ms. Soriano, you are recognized.
Good morning, Mr. Chair and the honorable members of this committee. On behalf of the JFC, which includes the American, Australian, New Zealand, the Canadian, European, Japanese, Korean Chambers of Commerce, and the PAMURI, or the Philippine Association of Multinational Companies Regional Headquarters, we express our support for proposals to ease or remove the economic restrictions embedded in the 1987 Constitution. We appreciate, of course, the opportunity to comment on the measures included for today's discussion. The JFC has long supported to easing the restrictions of foreign direct investments wherever this is possible. I think you would remember since the time of our former director, John Forbes, he has been actively participating in hearings on this matter. The removal of constitutional barriers can facilitate increased LDI in sectors where investment remains constrained, complementing the progress Congress has already achieved through the reforms of the passage of the Public Service Act, the Foreign Investments Act, and the Retail Trade Liberalization Act. We fully recognize the government's mandate to safeguard national interests. In many economies, we have seen that such safeguards are implemented through legislation or executive regulations rather than through permanent constitutional provisions. And thus, this approach would also allow the government to adjust quickly to technological changes, international commitments, and emerging global opportunities. Ultimately, the global economy increasingly depends on the free movement of capital and on a level playing field between the domestic and foreign investors. Providing clarity, flexibility, and openness in our investment environment is vital to sustaining competitiveness. We thank the committee for its attention and stand ready to work with you in promoting reforms that will enhance the country's economic growth and long-term development. Thank you, Mr. Chair.
Thank you very much, Ms. Soriano, for your comments. And we would also request the position paper because we wish to put a matrix of the statements and the positions of all our resource persons. You are the morning session. We have also in the afternoon session. And so now we proceed to hearing the President of the Foundation of Economic Freedom, Toti Chicanco. The floor is yours.
Maraming salamat po, Your Excellency, Congressman Rodriguez. First of all, I'm happy to note that Congress is moving toward addressing the structural problems of the Philippines. It's not our problems such as it's a matter of graft corruption or putting moral people in government. It is a structural problem which arises from the defects of a constitution that was made more than 30 years ago. So, with respect to the mode of changing the constitution, I support a constitutional convention in 2000
and 28, in the same time that there will be elections. The reason for this, of course, is a Constituent Assembly is quite controversial because of the suspicion of some people that Congress will only enact legislation that's or a constitution that's favorable for them. Besides, a constitutional convention will gather the widest possible participation of our people in changing the constitution. Unlike the 1987 constitution, in which only a few appointees crafted the constitution. As to what changes I would like to see in the constitution, there are a number. One is, of course, to remove all Filipino first and Filipino-only provisions in the Constitution, because these provisions have only resulted in the development of monopolies and oligopolies in the country. We need to remove all those Filipino first and Filipino-only provisions in the Constitution. The second thing is, I think, we need to develop a strong political party system in the country with state funding for political parties. So there's no more need for individual politicians to raise their own funds to be able to campaign and get elected. If we look at the history of other countries that have successfully developed, strong political parties have been behind their development. We can mention the Kuomintang in Taiwan, the LDP in Japan, the Communist Party in China, the PAP in Singapore, UMNO in Malaysia. You have also the Communist Party now in Vietnam. So strong political parties are behind development. So we need strong political parties. If we do not have strong political parties, the default will be, of course, political dynasties, because that's the only system of collective action. So we need to put in place a strong political party system with state funding for political parties. The other change that we would like to see is, of course, we need to shorten our constitution. It is one of the longest in the world. Therefore, it's straight brackets the country whenever there are technological or other changes. We need to shorten the constitution and let legislation take care of whatever restrictions or other developments that must be put in place to protect the Philippine economy. Finally, I think we need to put education as a center for social justice, as equalizing reform. So rather than asset distribution or taking away the land from another to give it to somebody, we need to put in place education as a center of equalizing reform for all our citizens, rather than asset distribution. So those are the things that we would like to see as changes in the Constitution. Maraming salamat po.
Thank you, President Toti Chicamco of the Federation of
Foundation.
Foundation of Economic Freedom. Thank you so much for your comments. And before we proceed, let me just acknowledge we have the Deputy Minority Leader of the ML Party List, the Honorable former Secretary of Justice, Laila M. De Lima. Welcome to the hearing. And we also would like to welcome the Deputy Minority Leader of ACT Teachers Party List, Honorable Antonio Pino. Welcome. And so we proceed now with hearing from the UP College of Law, and we would like to hear our two representatives, Associate Dean Attorney Paulo Tamase and Attorney Oliver Reyes. Please proceed.
Mr. Chair, committee members, good morning. Law Center is very thankful for your invitation for us to assist the committee in the consideration of these proposals. We will submit a full position paper, including the pros and cons, in particular of constitutional conventions and constituent assemblies. But if I may already premise what we will submit, the premise of our analysis, Mr. Chair, is that the people are central to our constitutional government. It means that their buy-in and trust in any process that will change the fundamental charter is necessary. If we look at our longer constitutional history, there have been many attempts, almost attempts in every Congress since 1987, to have some amendment or revision to the charter. And uniformly, that those efforts have failed, whether in Congress or outside through people's initiatives, because of a few things that our scholars in the Law Center have written about before. The first is the lack of certainty in the process. If we look at the textual ambiguities in Article 17, every time that we have a hearing in the House or in the Senate, we talk about whether the Senate or the House should vote separately or jointly, or should meet separately or jointly. There are, of course, views from academics as to the proper mode, but the lack of certainty and ambiguity increases the cost of an amendment, which may disincentivize people from engaging with the proposed amendment seriously. The second, and perhaps the more important block to successful change in the Constitution, would be public trust. And I think, as mentioned by the Foundation for Economic Freedom, changes in the Constitution have been dealt with suspicion in the past because they were perceived, notwithstanding fair debate and comment on whether we should have economic changes or changes to the economic provisions, they were often perceived as simply Trojan horses for larger changes on the political structure and term limits. This means, Mr. Chair, members of the committee, that the important conversations of whether the Constitution is still current are left out. And mature democracies rely on an intelligent, ongoing public discussion of what is truly fundamental to their society. Hence, we would suggest that any process to change the charter must be done in a transparent manner and not cut corners. In the past, I understand that there may have been ideas or suggestions, for example, for the House and the Senate to vote jointly because it would be the faster process. But unlike past occasions, we are perhaps just from a scholarly perspective, from an academic perspective, in the highest constitutional moment that we've had since 1987. In the sense that the people, because of the flood control issue, have come to the realization that if the failure is systemic, then maybe the system needs changing. So the House may wish to take advantage of that earnest desire of the people to seriously talk about their constitution in a mature democracy by going through the longer, more difficult process. That means that if the House were to propose amendments to the Charter directly, or if it were to call for a constitutional convention, then the least common denominator would be for the houses to vote separately but meet jointly. This would be the more arduous process, but it would satisfy the least common denominator of what it would mean to actually engage in this very important conversation. Now, as to the actual amendments, in addition to what Congress has already proposed to the bills, one important amendment may actually be clarifying Article 17. And that involves, cleaning up, Mr. Chair, members of the committee, the ambiguity between whether the process really requires the houses to meet and vote
jointly or separately. It seems like a very minor change to the Constitution, but the idea is to have a Constitution that balances both the required rigidity of a fundamental document that is not subject to policy changes for every few years, and at the same time being a current document that addresses really the fundamental needs of the people. So that openness, that transparent process is necessary, whichever mode may be chosen by the committee and by the houses eventually. We will submit a full position paper on this, but we would be happy to answer any questions that you may have in today's hearing and in the coming meetings. Thank you, Mr. Chair and members.
Thank you, Associate Dean Paolo Tamase, for your comments and for the College of Law and the Law Center. So we would like to hear now Attorney Oliver Reyes for your comments.
Good morning, Your Honors, Mr. Chair. I do wish to manifest that I entirely agree with Associate Dean Tamase and the position of the Law Center, and I would like to devote much of my time to actually just reinforcing several of those points. So, firstly, I do think that it is nearly anomalous that we have not really changed our constitution. I mean, especially when it comes to the experiences of other countries, constitutional amendments do happen as part of the normal course of a nation's life. But of course, in the Philippines, any discussion of constitutional amendments trigger this paralyzing existential crisis that ultimately deters any amendments. And I don't think that that was really the design of the Constitution, which after all does allow for amendments, and in fact tried to open up the amendment process by introducing the concept of people's initiative. But I do agree that a lot of the issues, in fact, a lot of the perhaps even deterrence to even pursuing any kind of amendment is the lack of clarity when it comes to Section 1, Article 17. Now, any serious attempts to amend the Constitution would have to hurdle and in fact would require both the House and the Senate to come up with, at the very least, a provisional interpretation of what this provision means in order to actually enact the amendment. And the problem is, if more significant amendments, more substantive amendments were to be pursued on the guess that this is how the Supreme Court will affirm the interpretation of Section 1, Article 17, that is an investment that may be ultimately lost because it will all await the Supreme Court's word. But if the initial amendment to be pursued actually centered on Section 1, Article 17, and then the Supreme Court rules on the issue of voting jointly and separately, or affirms or rejects how both houses of Congress had proceeded, at least now there would be this clear guidance from the Supreme Court as to how to be able to successfully pursue other amendments. So perhaps that is really something worth considering. And also, moreover, on the point of needing to build public buy-in towards the Constitution, an initial discussion on amending the Constitution to clarify Sections 1, Article 17 can already test the waters, so to speak, as to the public appetite in amending the Constitution now. And I do think that with all of the flood control scandals, with the impact that has had on public trust in our institutions, this is as opportune a time as to perhaps discuss even these existential questions. And I do think on the point of whether or not to pursue amendments or to call for a convention, I think that to call for a convention and to essentially undertake a revision of the Constitution, an entire holistic analysis of the structural changes, as part of the need for transparency and public confidence, I think it should be understood that this would be a measure that would require actually, and for at least a few years, a redirection of the public focus, of the focus of our institutions, of our public discussions on how do we proceed forward as a nation. Because after all, the Constitution is the foundational document. And I think that a constitutional convention and a revision, I think it should be understood that if we do decide to embark on this process, re-examine the whole Constitution, it would require this redirection of the public focus. And I think that that should be part of the buy-in that would be required. But at the same time, as I said, it should not be that difficult systemically to amend the Constitution. And and I do think that a lot of the proposals, which I'll reserve comment on, but a lot of them would only entail amendments. And the clarification of Section 1, Article 17 would go a long way to, well, having those discussions. Thank you, Mr. Chair.
Thank you very much, Aniero, Attorney Reyes. And we would like to, before proceeding, welcome Congressman De Maguila for coming, Arman for coming to this hearing. Thank you very much for coming. And so we are about to have the last speaker on the private sector, because after Dean Aquino will hear our officials of government. So you'd like to hear now the Reverend Father Rangelio Aquino, San Beda Graduate School of Law. Please proceed, Reverend Father.
Good morning, Your Honors. I also respectfully request for the opportunity to submit a position paper after this. I favor an amendment of the Constitution if we are minded to go no further than an amendment. Aside from the grounds advanced in the privileged speeches that introduce the measures, the issues our nation has had to grapple with lately demonstrate quite clearly to me, and perhaps to others as well, that systemic change is necessary. Frequently, objections to amendments of the Constitution are tied to some kind of a sentimental attachment to the 1987 Constitution. There is no doubt that it is a well-written Constitution, but that is not to say that it cannot be improved. I favor the position expressed by the UP Law Center that amendments to the Constitution or even a revision of the Constitution calls for the involvement of as wide a spectrum of Filipino society as possible. This means that consultation on fundamental levels of society, LGUs, barangays, youth, should accompany the groundwork for constitutional amendment or revision of the Constitution. I also seriously advance the proposition that it would be good to get the support of the church. It's not because I'm a priest, but the fact is that the church has considerable influence in Philippine society. And so to get the church on board and to make use, for example, of consultation through its basic ecclesial communities would be very good. It is common to dismiss the need for system change with the easy contention that it is people that need to change, without in any way being dismissive of the truism that we need civic spiritedness among those who hold public office, as well as among those who choose those who hold public office. It is, however, a position I strongly maintain as a professor of philosophy, as well as of comparative constitutions, advocating, well, that decision-making processes of persons are conditioned by systems. So it's not correct to say, change the people and the system will be okay. No, because in many ways, systems do condition the way people act. And so we do need to take a look at the system. Systems channel the decision-making processes of persons and condition public life. I am by no means advocating a clean sweep of the 1987 Constitution that is in several respects exemplary. Nobody, I think, would support the proposition that every single section must be rewritten and every salutary provision of the 1987 Constitution, drafted to my mind by people of integrity, probity, competence, and noble intention, should be stricken off and set aside. However, Your Honors, the theory of constitutionalism is precisely that society can be reorganized and its body politic reconfigured by rewriting the Constitution. It is for this reason that I favor not only an amendment of the fundamental law, but as the Vice Dean of UP Law said, a revision as well. And the principal revision I strongly advocate is a system of government that puts a premium on the accountability of government. And given the different political configurations of the branches and offices of state that we are taught both by history of the constitutions and of states, the parliamentary system is one that holds government constantly to account to the representatives of the people. The fact that the Prime Minister and his ministers sit in Parliament and must respond to questions and challenges that arise not only from across the floor, but from backbenchers as well, convinces me that the parliamentary system is one that allows for a constant check on government. I know that the objection will be heard that we have never tried the parliamentary system in the country, at least not the parliament of the Westminster type. For while it is true that the 1973 Constitution intended us to have some kind of a parliamentary government, the vast powers granted the President under the contentious Amendment Number 6 made an experience of genuine Westminster-type parliamentary government virtually impossible. Together with the shift to a parliamentary system and as its presupposition, I advocate a constitutional framework for the establishment, maintenance, and support of a viable party system and the adoption of proportional representation. I was part of the 2016 committee tasked to study the 1987 Constitution. And while I was averse to proportional representation, in large measure because I did not see the point to it, it eventually occurred to me that you cannot promote a party system in the Philippines, a nation that tends towards populism, without the system of proportional representation that compels voters to look to parties and what they advocate rather than persons and the families they come from. If, however, this committee and other committees are minded merely to confine itself to amendments, I submit that the following measures need to be addressed. One, a self-executing provision that bans dynasties up to the second degree of consanguinity and affinity, whether successive or simultaneous. Second, the abolition of the party list system that has been mangled beyond recognition and prescribing for part of the membership of the House of Representatives by proportional representation. Third, amending Section 22, Article 6 of the Constitution so that cabinet secretaries and officials of the executive branch are subject not only to invitation, but to compelled and mandatory attendance without Congress or its chambers or committees having to justify its summons by claiming to be acting in aid of legislation. The oversight to which the legislature, I submit, is entitled is sufficient constitutional justification for this grant of power. Fourth, our experience with congressional investigations that do not result in prosecution has been a source of national frustration. I propose that when Congress conducts a hearing, whether in aid of legislation or pursuant to its oversight functions, and the committee report, as confirmed by the plenum, finds probable cause against perfidious public servants, the report itself becomes the basis for prosecution, making it ministerial on the part of the National Prosecution Service or the Office of the Ombudsman to file the corresponding information before the court of competent jurisdiction. Your Honors, I favor a constitutional convention because constitutional amendments or revisions introduced by the chambers of Congress exercising constituent powers will always invite the suspicion that the actuations are self-serving. I do propose, however, that a constitutional convention be constituted, one half of the members of which are elected and the other half appointed from experts in constitutional theory, political science, economics, commerce, social theory, and juridical science. I shall submit my position paper after this, Your Honor. Thank you very much.
Thank you so much, Reverend Father Ranilio Aquino of the San Beda Graduate School of Law. Before we proceed, let me acknowledge the presence of the Honorable Rene Co of the Kabataan Party List. Welcome. And I see also Len Oreta, Congressman of Malabon. Welcome to the hearing. Now we are through with the private sector. We will hear now representatives of government. So thank you for coming here and to be able to give your position. And now, first we'd like to call on Assistant Director Judith Gondra of DepDev. The floor is yours. Thank you.
Thank you very much, Mr. Chair. Thank you for inviting DepDev to the hearing. So we will be submitting our official position paper next week. But for now, we can say that DepDev supports the intention of to amend economic provisions of the 1987 Constitution for the following
Please have your
reasons.
microphone really in front.
Okay, for the
We
following
have a
reasons.
problem with the sound.
Sorry. Okay, Mr. Chair. Okay. On the economic provisions, specifically those that restrict ownership, management, and control of certain enterprises and activities have contributed to low foreign investment inflows and scarcity of major global enterprises in the country. These economic restrictions, in turn, have led to limited access to economic and social opportunities and the proliferation of highly concentrated markets, ultimately reducing consumer welfare. No, and amending economic provisions enables the country to adapt to current and future socioeconomic conditions. This support is driven by a collective desire to economic and social transformation that will be instrumental in uplifting the lives of all Filipinos. And amending the economic provisions is expected to result in positive gains and provide the Philippines with additional tools for prosperous, inclusive, and resilient economy in the form of more foreign direct investments, international education, globally competitive mass media, international advertising, and modern utilities. The proposed amendments will also allow flexibility in the Constitution to respond to different political, economic, social, technological, legal, and environmental shocks accordingly and in timely manner. However, DepDev notes that lifting the foreign investment participation alone will not solve the country's position in attracting strategic foreign equity, but it is just one of the factors that need to be addressed, Mr. Chair. So in terms of the mode of amendments, it will be form part of the our position paper, which will be submitting next week. No, as we are currently updating our comparative matrix as to the modes, if it is con or con-as. No, we will be also submitting our assessment of the in terms of costs, no, of both mode of amendments. So that would be all, Mr. Chair.
From the DepDev, and also from DepDev, we'd like to hear Ms. Janice Utanes, the Supervising Economic Development Specialist.
Good morning, Mr. Chair and honorable member of this committee. Just to add to my principal, AD Judith Quandra, I would like to answer the question, what specific amendments do you want to propose? Like she mentioned a while ago, we want the committee to consider the following sections: the one on public utilities, on education, on mass media, and on advertising. And then just to add to her manifestation, we believe that lifting the foreign investment participation alone will not solve the country's weak position in attracting strategic foreign equity, as it is one of the critical constraints that we need to address are these number of we call these factors, such as predictable investment environment, the market size, and the level and quality of infrastructure, peace and security, our tax regime, and political institutions. That's it, Mr. Chair. Thank you.
Thank you very much, Ms. Utanes. Now, for our last resource person, we'd like to invite Yusek Domini Velasquez, Chief Economist, Department of Finance. The floor is yours, ma'am.
Good morning, Mr. Chair. Thank you for inviting us here. I think most of the things have been mentioned by Mr. Barcelon and DepDev for the DOF. We also welcome this review, especially for the economic provisions. We can recognize that in the past 10, 15 years, the country has been very open to foreign direct investments as with the help of Congress, with the liberalization reforms that we've put in place. This administration, the stance remains the same, as we've also pushed for not just the liberalization efforts, but leveraging on this with incentive packages such as Create More and the Foreign Investor Long-Term Lease Act and the like. So right now we're at the stage where we want to encourage foreign investments through these liberalization reforms we've done in the past. Unfortunately, we recognize also that this is very uncertain times. We have not seen much of the fruits of these liberalization and incentive reforms just because of the uncertainty in the global environment. For us, similar to our position before, we welcome much more needed liberalization of economic provisions, possibly with public utilities, advertising, maybe higher education. We also want to note that the 2023 OECD data with regard to restrictiveness of regulatory of FDI regulatory restrictiveness index puts the Philippines second to the most restrictive in ASEAN. So that's after Laos. So Philippines, Malaysia, Indonesia, and of course at the end of the spectrum, Singapore. Additionally, we wanted to note that foreign direct investments to spur for FDI, it's not just limited to the regulatory reform or liberalizing it. There are other factors such as ease of doing business, good governance that require a review for the country's overall attractiveness. So in terms of the mode of amending the Constitution, the DOF has no specific recommendation. We defer to the collective wisdom of Congress on this. Thank you, Mr. Chair.
Thank you very much, Yusek Velasquez. So now we will ask our members if they have questions to propound to our distinguished resource persons. We always start with the minority. And and in the minority, the first come, first serve. The same also with the majority, first come, first serve. So we like to ask the first one who arrived from the minority is the Honorable Laila de Lima for your questions, rhetorical questions. Thank you.
Thank you, Mr. Chair. Good morning. Good morning to our distinguished resource persons. I just have a few preliminary questions at this point. This is the first time that I have attended the committee hearing of this committee. I don't think there is hardly any debate that the Constitution needs some adjustments already, some changes, some modifications. Now, I just want certain clarifications here. Are we pushing for just amendments or revisions? Will the proposed constitutional convention be dealing with amendments on specific issues or priority areas for changes? Or are we talking here about revisions? Because we all know that amendments and revisions to the Constitution are two different concepts. Can we ask any of the distinguished sponsors or authors of the pending bills to please clarify? Because the reason why I'm asking this, Mr. Chair, is in House Resolution number 460, it says a resolution calling for a constitutional convention to propose amendments to the 1987 Constitution of the Republic of the Philippines. This was filed November 12. But the day earlier, actually, the bill itself, which is House Bill number 5870, filed or authored by the same authors of the resolution, resolution number 460 says, well, the title is an act calling for a constitutional convention to propose amendments, revisions, corrections, and changes to the 1987 Constitution, setting the election date of delegates, prescribing the composition, powers, and functions of the convention, providing for its appropriations and for other purposes. So this is broader, not only amendments, but also revisions, corrections, and changes. So am I correct in perceiving that we are actually contemplating here or envisioning revision and not just amendments to specific items, the ambiguities? Because I do believe and I agree and I concur with the idea that we need to clarify ambiguities because there are ambiguities sa ano pa lang, dun pa lang sa impeachment. The forthwith terminology, the use of the term forthwith, and with the Supreme Court decision, it looks like if it's not reconsidered, then it's next to impossible if any future complaint for impeachment would prosper. And then with this voting about whether it's jointly or separately on certain items. So can we be clarified, please? Because to me, this is very crucial, whether we are talking here about just amendments to the more important and more urgent provisions, or we're talking here about revisions.
Thank you,
Should be
Congresswoman De
hosted.
Lima. Before Deputy Speaker Puno can answer that question, may I recognize Deputy Majority Leader Arnan Pangaligan? Thank you, sir. Deputy Speaker Puno is now recognized.
Thank you, Mr. Chairman. Your Honor, we purposely avoided specific amendments in the resolution that we submitted. Our resolution intends to define the method that will be used in order to either revise, amend, or otherwise deal with the Constitution. We feel that there are just so many specific amendments that can be brought forward by many experts and we do not presume to be experts in all fields. We did mention some inconsistencies and ambiguities that we felt should be immediately addressed. But the body of the resolution merely provides for the method of how the Constitution will be reviewed. So it was our hope that in the proceedings in this committee, that if such ideas will come in as to whether or not there should be clarifications or actual revisions, that this should be discussed in committee. We did not presume to be knowledgeable about what would be the best course of action for the committee at that time. So we believe that this format of our resolution will allow for more discussions to give substance to the method that we're going to use for the Constitution. It merely stems from the fact that there have been people's initiatives that have been ruled down and stricken down by the Constitution a number of times over the many years. It comes at a time when both houses of Congress are under criticism by many quarters for various actions done by both houses. So we feel that, for example, a constituent assembly is probably not the best suggestion to make at this time if we are going to seek the full confidence and faith of our people. And we don't believe that a people's initiative is any longer feasible, especially under the situation where the Supreme Court has already ruled many times about the various efforts at a people's initiative, which leaves us only with a constitutional convention to deal with these issues. So, in summary, our resolution merely provides the methodology and venue for the consideration of these issues, Mr. Chairman, Madam.
With that explanation of our distinguished colleague, our distinguished sponsor, I take it therefore that we are confronted with two situations here. So one is that this proceedings, these discussions at the committee level does not exactly foreclose the idea of already identifying certain priority areas for possible amendments. Correct. Already identifying in the bill.
Yes, if I may, Mr. Chairman.
Does not foreclose, actually. Or it will also be, one scenario also is that the Constitutional Convention as envisioned in the bill is, we would be given full discretion to determine the scope of amendments that can cover even the form of government. And then, for example, also even the proposed abolition of the party list system, as mentioned by the Reverend Father Aquino. Good morning, Father. Good to see you here. So it would be given the Constitutional Convention as envisioned would be given the full discretion to determine the scope of amendments. So, and therefore, it would not just be really amendments, but it would be revisions. So those are the two possible scenarios. We can be more circumspect and we've been more careful by already identifying what the specific priority areas or areas that will be covered by the amendments of the Constitutional Convention to be tackled by the convention, or full discretion that would open the doors to all types of changes in the basic charter. Is that correct?
Yes, thank you, Mr. Chairman. The resolution that we submitted was submitted in the context of other resolutions already submitted to the committee for specific amendments and their own methods of amending the Constitution for those purposes. So we were anticipating that there will be a period of discussion and all of these resolutions would try to be reconciled. And therefore, the specific amendments that were mentioned by everyone else would also be brought to a discussion. With respect to what the Constitutional Convention will actually do, as we know, there are two steps to this Constitutional Convention. First, we have to come up with a joint resolution from 2/3 vote of both houses or either house of Congress that a Constitutional Convention will be called. After which a more specific law is called upon, which is also going to only require a majority where the particulars of the convention will be discussed, including what Your Honor, Mr. Chairman, has mentioned about the the specific items that will be covered in amendments. So that is why we presented our resolution in this way, because it opens up, of course, the discussions for the second legislation that needs to be undertaken, which is to provide for the specific conditions that will govern the Constitutional Convention after the convention has been decided to be called by both houses of Congress.
The salt of the moment, because I just want to clarify really the parameters of the proposed bill, and I reserve the next hearing my proposals. Thank you.
Thank you, Congresswoman De Lima. In the order of priority, next to propound question is Deputy Speaker Puno, to our resource speaker. If you have any question.
Well, yes, thank you. There was mention of the possibility of appointing members to the Constitutional Convention by Dean Reverend Father Aquino. I was just wondering what details would enter into this process of appointment. Of course, we ask this in the context of the necessity to reassure everyone that this process is for the benefit of the entire country and not for different segments of our political spectrum. What if there is any? May I ask if there is any more specific idea on how such an appointment process could be conducted?
Your Honor, actually, the Constitution does not provide anything about the composition of the Constitutional Convention, and therefore, impliedly, the Constitution leaves it to Congress that convenes the Constitutional Convention to determine the composition of the convention. The reason that I proposed one half elected and one half appointed was that I was a minor seminarian, a high school seminarian, at the time of the elections for the delegates to the 1973 convention. And I know for a fact that even if the elections of delegates was supposed to have been non-partisan, it was actually very partisan, with many politicians openly supporting candidates to the 1973 convention. So knowing that that is a distinct possibility, it will be good to have one half appointed because of their expertise. And that is why, Your Honor, I propose that the appointees come from the ranks of those teaching constitutional theory, political science, political theory, social theory, and economics. That way, there's a balance between those who are there because they are popular and those who are there because they have the know-how and they have the necessary academic credentials for.
Thank you, Mr. Chairman. We look forward to the position paper that the Dean will be submitting
Yes, sir.
to this committee. We hope that there will be more details submitted to this by our honorable resource person and the others, because these are the matters that will be covered in the second legislation that the Congress will be required to undertake with respect to the specific characteristics of the Constitutional Convention. It would be very helpful to us. I think we all agree that that what is going to be critical to any constitutional convention is the quality of the delegates that will be brought there, the objectivity, and of course the nation-mindedness of those that will be there. So that is indispensable to any constitutional convention we are going to hold in place. So we would really look forward to your position paper, Dean, and of course also the UP College of Law and the other educational institutions that are involved in this process and will be coming in the later hearings. Again, these are going to be specific provisions that may be contained in the legislation that actually defines what the Constitutional Convention will look like.
Attorney Paulo of UP College Law.
Thank you, Mr. Chair. I think we share the observation that the constitutional amendment provisions do not actually provide for an election. However, and because ultimately, in light of the climate, any change in the constitution should be expected to come to the Supreme Court at some point for its validity. The deliberations of the 1986 Constitutional Commission seem to suggest an election. So I understand that this was already contemplated in the last Congress during the debates on the proposed amendment where there would be appointed members of the convention. But in our research for that undertaking, we found that the framers were quite categorical in terms of it having to be an elected convention. But perhaps in acknowledgement also of the importance of a broad public consultation, there is nothing that stops Congress from creating within the law for the convention a consultative committee that will be made up of appointed officers that can be consulted by the convention at their discretion and their will. Thank you, Mr. Chair.
Mr. Chairman, if the College of Law could give specific suggestions on how this thing might be done, we would welcome it because, again, this will be part of what might be contained in a defining law for the Constitution.
We will be happy to provide that, Mr. Chair. Thank you.
Attorney Paulo, since things was mentioned dealing with the deliberations of the Constitutional Convention, the framers of the 1987 Constitution, can you enlighten us on the discussion on the mandatory provisions, whether there was discussion on voting jointly or voting separately?
So, if we look at the records of the 1986 Constitutional Commission, the discussion of whether there would be a joint voting or a separate voting isn't present because of the accident that when the amendment Article 17 was being drafted, the commission the commission contemplated a unicameral Congress. So the text of the Article 17 actually reflects a unicameral Congress. The decision to pursue bicameralism is one of the last decisions that the commission took. And when they did, and the style was changed for the rest of the Constitution, there was, by some accident, leaving out the proper amendment to Article 17 to make it reflect a bicameral Congress. So that is reflected in the scholarship of former Supreme Court Justice Vicente D. Mendoza a few years ago when this issue was also up. If we look at the 1935 practice, the 1935 text of the Constitution is definitely more categorical. The text, and I am paraphrasing a bit, says that Congress, by joint session assembled, may propose amendments to the Constitution or call for a convention voting separately. So those joint meeting and voting separately were explicit in the 1935 text. Unfortunately, because of the amendment of the drafting history, rather, of the 87 Constitution, it was not as clear when we got to our current Article 17.
So, but the manner of voting jointly in the 1987 Constitution is not a new concept, right?
Voting jointly would be definitely new for the amendment or revision, Mr. Chair.
What I'm saying is there are instances in the 1987 Constitution wherein considered of supreme and paramount importance that Congress vote jointly. Like, for example, the revocation or extending the proclamation of the habeas corpus, the revoking or extending the declaration of martial law. These are two supreme and paramount importance wherein in a joint session, Congress vote jointly. Tama po ba?
Mr. Chair, I share the observation that these are important. But if we look at the instances where voting jointly is allowed, when I think, if I am not mistaken, the declaration of the state of war or the revocation of martial law and those instances are not so much because of the importance of the matter, but because of the expediency. So because there is a war or an emergency, it is necessary to gather Congress in one assembly rather than try to have them vote separately. In every other instance, the Congress is bicameral. And bicameralism in the Constitution acknowledges the independence of the branches of the House and the Senate. That is why in the impeachment, just to tie it to that illustration, the UP College of Law Constitutional Law faculty's observation was that the Senate could not dictate upon the House on how it would proceed with the process. So even in non-legislative settings, the default is bicameralism, except in those rare instances of expediency that are reflected in the Constitution.
Rani, you may say something.
Your Honor, without wanting to pick up a quarrel on this point with the esteemed representatives of the University of the Philippines, it's a fundamental precept of constitutional hermeneutics that the intent of the framers is to be found in the text of the Constitution, and that recourse to what happened in the history of the framing is made only when recourse to the text is not sufficient. So whatever may the intentions may have been and the historical accidents may have been, the fact is that the text is voting, it doesn't say whether it's voting jointly or voting separately. And therefore, my own position is that there should be no constitutional objection to voting jointly. And my reason for that is that if you say they have to vote separately, then the other objection that could come in there is that Senate, which is composed of far fewer members than the House of Representatives, could effectively interdict any initiative on this matter by the lower house. And that would be, I think, an argument that voting jointly would not be anathema to the Constitution.
Thank you, Mr. Father Rani. Any other manifestation or comment?
Just to perhaps to respond to Father Rani's intervention, which I think really does follow the idea that the text should reflect the intent of the framers. The framers' intent is reflected in the text rather. The court nevertheless acknowledges that there are times when there would be ambiguities, and we do resort to rules of construction. One of them, and one that it has depended on quite frequently, is the intent. As to whether the Senate is able to effectively overrule the more numerous House when they have to vote separately, then, Mr. Chair, Your Honors, my submission would be that is precisely the constitutional intent. When bicameralism was selected by the framers, the intent was for policy to be considered carefully by a more numerous House and a smaller House, so the Senate and the House. And in the particular case of constitutional amendments and revisions, it might not be it might be absurd, to put it frankly, for the process of changing the Constitution to be easier than it is to pass normal legislation. If the intent is for constitutions to have some sufficient rigidity so that they do not change with election year policies, then it would be expected that it would be not a very easy task to do. But that is all, Mr. Chair.
But isn't it the fact that all proposals should be approved in a plebiscite called for that purpose? Meaning, any proposals remain a proposal. unless inaprubahan ng taong bayan, which is the true honor of the Constitution, yung Filipino people. Because in the parity of voting, the destination of democratic representation in its purest form is, one person, one vote. Tama po ba?
That is right, Mr. Chair. But that, if I may add, that pertains to the popular vote. It doesn't pertain to the rules that the Constitution have created for the members of its two separate houses of Congress.
No, Congress sitting as Constituent Assembly, proposing amendment to the Constitution, we're no longer considered as legislator here, but exercising our constituent power to propose amendment to the Constitution. Tama po ba?
That is right, Mr. Chair. And I hope I am not misciting the case that was also affirmed by the court in Gonzalez versus Comelec, 1971 decision. But the court clarified that when a convention or Congress, in this case, exercises constituent power, then the exercise of constituent power is not pure constituent power. It is the exercise of constituent power according to the Constitution. And if the Constitution places certain limits on how Congress can exercise it, then those still have to be complied with and also subject to some judicial review.
Anyway, thank you, Attorney Paulo. Father Rani.
This is not a rebuttal, sir. Number one, when the Constitution says Congress, the Supreme Court has not always interpreted that to be both chambers. When the question once arose on the membership of the JBC and Congress was allotted one seat, the question was, should that not be read as two seats since Congress is bicameral? And the Supreme Court said, no, only one seat. Only one seat. So it is not accurate that the Supreme Court has always read Congress to mean two chambers. And the other thing is that while we may fear that the lower house may introduce changes by sheer propensity of numbers or preponderance of numbers, the ultimate check will be submitting it to the people in a plebiscite or a referendum.
Thank you, Father Rani. So when the Constitution says 2/3 or 3/4 of all its members exercising its constituent power, it does not refer to its legislative power, the exercise of its constituent power, that ultimately any proposal will go to the approval ng taong bayan. Salamat po. Representative Copilar is now recognized.
Yes, thank you, Mr. Chair. To the Philippine Chamber of Commerce, how can we balance the interests of local business with foreign? To Mr. Christopher Ilagan. Yes. How can we balance the interests of local business with foreign interests if we are going to totally delete the restrictive economic provisions instead of putting the phrase unless otherwise provided by law? Can you respond to that?
Thank you, Honorable Congresswoman Copilar. I'm not a lawyer, so that's just a disclaimer here. No? I guess to the point that we heard from our friends from the Federation of Economic Freedom, no? And I think it was PCCI as well. By removing these restrictions doesn't necessarily mean that you will not have the liberty of passing laws that may put in the proper safeguards, the guardrails for certain sectors. And I think, when it comes to the likes of national security and what have you, right? It's the laws that come out afterwards that put those restrictions on certain sectors. But, having said that, I think that ultimately what we're looking for, and that's the reason why we need a little bit of time to prepare the position paper. We'd like to word it in a way that it doesn't open up the economy without giving Congress the opportunity to put restrictions where they need to be, especially when it comes to matters such as national security.
Thank you. The reason I asked that, syempre, natakot din tayo na makakainin ng malaking kumpanya yung mga small businesses natin na nagsisimula pa lang. So we will wait for your position paper. And last, Mr. Chair, I would like to ask Attorney Paolo Tomasio from the Associate Dean of UT College of Law. Since there is a deadlock between the House and the Senate regarding sa interpretation of Section 1, paragraph of Article 17, would it be prudent to seek guidance to the Supreme Court to interpret the said provision? Kasi laging nagtatalo dyan, jointly, separately, but the framers during they drafted the 1986 Constitution is a unicameral system. Eh, hindi naman yon ang nangyayari.
Mr. Chair, thank you for the question. My understanding is that there is no process currently to ask for the court for a pre-clearing of the mode that the Congress would choose. And that also comes from limitations on what judicial power is. We often look at the court's role as the final arbiter of constitutional questions, but the initial answers actually come from the other branches. And Congress is empowered by the Constitution to engage in the same constitutional interpretation. Of course, the result of that in an ambiguous text is really a deadlock, a possible deadlock. So it calls on Congress to do one of two things, in my view. The first thing is, well, the first option is for Congress to test the waters. If it really wants to proceed to a Supreme Court's determination of this, then it can try out the amendment process it wants to and then wait for the Supreme Court to decide. But the second option, and with all due respect to the Supreme Court, what I believe is the more democratic option is for Congress not to let the Supreme Court decide this, or just to plant the case for the Supreme Court to ultimately decide on it. There are mechanisms between the House and the Senate for it to coordinate. And one of them might be to clean up whatever ambiguity there is in Article 17, either through an initial preliminary interpretation by both houses, if it agrees to it, or to propose a proper amendment to Article 17 to simply clarify the process. If it wants to do a joint voting, then it should say joint voting. If it wants to do a separate voting, then it should do a separate voting. Because in my view, Mr. Chair, ma'am, if we look at the longer history of attempts to change the Constitution, it has uniformly failed because of the ambiguity. It increases the cost of actually trying to talk about constitutional amendments because everyone just thinks that the Supreme Court will ultimately decide it. And with all due respect, that is not good for democracy. So Congress, as the House of the People, and the Senate, as also that similar House, would benefit by a more democratic determination of what the process should be. Thank you.
Attorney Paolo, for two Congresses, the 8th and 19th Congress, we were able to adopt a resolution proposing amendment to the Constitution, approved by supermajority of the members of the House and was transmitted to the Senate. But consistently, the Senate did not act on it. Ang tanong ko po, halimbawa may maipasa ulit kaming resolution ngayon calling for either CONCON or CONAS or a piecemeal amendment to the Constitution at isinumiti namin sa Senado. Sabi mo kanina kasi, wala pang trigger para yung Korte Suprema ay mag-acquire ng jurisdiction over that constitutional question. Yung inaction ba ng Senado that always frustrates those meaningful amendment, proposed amendment to the Constitution, would it trigger shall we call a justiciable controversy?
Mr. Chair, if I may have a few seconds to consult. Mr. Chair, if I may answer the question, at best, the House may argue before the court that that inaction would also be in grave abuse. Because as part of the equal relationship that the Constitution ordains between the House and the Senate, then the Senate must act on somehow with as to the amendments or the resolution of the House. But that would be, of course, subject to all sorts of objections before the Supreme Court as to whether that duty is actually present, whether that duty is ministerial, and similar objections. But just to add to that, there might be a possibility that the climate this time is different just because of what scholars would call a constitutional moment. That is when the people and the branches of government come to an agreement that there's something that needs to change in the fundamental arrangement of society. And one of the indicators that that constitutional amendment is the frustration, I think, as the three of us mentioned earlier, the flood control issue. So that might be an impetus for the Senate to actually consider a resolution passed by the House, depending, of course, on the substance of the amendment or revision that is proposed from the House. If it pertains to the procedure in Article 17, it might be sufficiently neutral enough to encourage discussion and therefore encourage the Senate to take it on. But if it were to be a more substantive amendment or suggestion, then you would be able to expect some pushback on the part of the Senate. It's just from observing past attempts to change the Constitution. Thank you, Mr. Chair.
Thank you, Attorney Paolo. To proceed, and the next to ask question is Deputy Minority Leader Congressman Tino.
Well, Chair, thank you for recognizing me. Actually, siguro I will just share some observations and thoughts. Una, I think sangayon ako kay Congressman Puno dun sa sinabi niya, no, na bagaman nasa agenda ngayon, kasama yung bills on amendment via CONAS, no? Pero talagang sa panahon ngayon ay hindi, palagay ko hindi papasa yan. Given, alam naman natin, no, na dahil sa flood control issue ay napakababa ng credibility ng House at saka ng Senate, no? Kaya matagal nang may palaging nabibigo ang mga tangka na baguhin ang konstitusyon kahit noon pa man dahil ultimately dahil walang tiwala ang mamamayan, no, sa mga nakaupo sa House at Senate, no. Palaging iniisip nila ang gusto lang gawin niyan ay term extension, so on, di ba, mga ganon. Okay, so I would agree with that na kung may panukala man ng pagbabago ay hindi naubra yung moda ng CONAS. Okay, so merong proposal for constitutional convention, maybe yun ang dapat mas pag-usapan if ever. Tapos pangalawang, so in other words, ang tanong ngayon, ano ang layunin ng ating mga hearing? Are we here for an academic discussion, okay, of the of proposed amendments, no? Well, if we are, then let me add a few observations. Kaugnay dun sa economic provisions, palaging yan yung isa sa mga major na agenda, tapos matagal na rin, actually, mula pa nung, panahon pa ni FVR, di ba? Diyan na nagsimula yan eh. Yung critique sa Constitution, the neoliberal critique, which is to say, marami daw protectionist provisions ang Constitution sagka ito sa pag-unlad ng ekonomiya. That critique emerged in the 1990s during the heyday of neoliberalization, of globalization, di ba? Pero so hanggang ngayon, narinig ko pa rin mainly na ganito ang dinadalang posisyon ng mga resource persons natin, lalo pa from the business sector. Okay? Pero sa totoo lang po, lumipas na ang ilang dekada at ngayon, hindi na po unquestioned yung neoliberal dogma that everything should be opened up, protectionism is bad, and so on. In fact, ngayon ay nakikita na ng marami na masama o hindi nakikinabang ang mayorya ng mamamayan sa mundo sa walang sagkang free market globalization. And in fact, this was highlighted during the pandemic. Nakita doon, for example, mahalaga ang proteksyon at pagpapalakas sa sariling produksyon. No? Local industry, local manufacturing, local or domestic agriculture. No, nung panahon ng pandemic, nakadepende tayo sa practically nagmakaawa ang si Duterte sa Vietnam. Vietnam, please, during the pandemic, wag niyo itigil ang importation ng bigas, no? So, kumbaga nagbabago na rin po ang economic ang nauusong mga economic doctrine ngayon. So bumabalik yung recognition sa kahalagahan ng protection and development of our own industry and agriculture. No? So yun lang po. Unfortunately, sa mga resource persons na narinig natin dito, parang di pa rin na yung pa rin mga dati ang naririnig ko na basically pro-importer. No, na dapat, we don't want a protection of local monopolies, so buksan natin sa importation. Nakikinabang ang mga komprador na tinatawag ng mga aktivista, mga burgesyang komprador. Tapos, to the detriment, okay, laging pabor sa importer. So nakita natin, pag pabor sa importer, actually, nawawasak ang lokal na agrikultura natin. Pabor sa importer, wala tayong domestic industries. In the 90s, we saw a wave of economic growth in our neighboring Southeast Asian countries, yung Malaysia at Thailand. Bakit sila umunlad? Dahil nag-focus sila sa manufacturing, hindi lang assembly. There was technology transfer, so meron silang mga sariling industriya na na-develop. Ngayon, there's another wave. Andiyan na yung Vietnam, yung Cambodia, again, susi doon, manufacturing. Mamaya, maiwanan naman ng Pilipinas, mamaya, maiwanan naman tayo ng Laos. Gano'n na. No? So, siguro yun lang po, Mr. Chair, yun ang mga punto na nais kong i-share dito na una, baka dapat tanggapin ng komite na dead in the water na tong CONAS. No? Pangalawa, nire-raise ko lang no, na dapat questionin natin yung neoliberal dogma. Okay, napangiiwanan na po yan ngayon. At mas mahalaga ang pag-focus sa national industrialization at saka sa pagpapaunlad ng ating agrikultura. Yun lang po, Mr. Chair.
Thank you, Congressman Tino. May we recognize Congressman Benny Abante of the 6th District of Manila. Sir, thank you for coming. Next to ask question is the Vice Chair of this committee, Congresswoman Lagbas. You're now recognized.
Thank you, Mr. Chair. I just wish to manifest my full support on continuing support as well for House Bill number 5870 and House Bill 460 measures that I have already joined as author. While my authorship already places me on record, Mr. Chair, I wish to reiterate this here in the committee to underscore the need for an inclusive, transparent, and participatory process. Constitutional reforms requires perspectives not only from legal and academic experts, but also from the communities that will ultimately be affected by these changes. While we are all here today, naisip ko po yung mga kapatid natin na nasa grassroots. Siguro nag-wonder sila kung ano na naman ang direction natin, kung ano yung proseso. May I kindly ask po from the resource speakers, what are the specific measures that you can suggest for this committee to undertake to somehow bridge the disconnect of this committee of the constitutional reform and the people from the grassroots? Yes, Mr. Chair, I would like to ask the opinion po of the resource speakers na pag-usapan po natin na importante po yung proper dissemination ng information din sa grassroots and all, as eventually sila naman po ang affected kung ano man ang mga pagbabago sa Philippine Constitution. Sa dami pong instances na nag-take ng effort ang Constitutional Amendment Committee para po ipagpatuloy ang amendments ng Constitution, yung mga tao po natin, mga kapatid natin sa grassroots ay palagi pong may distrust sa proseso. Would you possibly have a concrete suggestion on how to alleviate this distrust from the grassroots?
Any would like to answer of the resource persons?
Thank you, Mr. Chair. If I may answer the question. If we look at past, kung titignan po natin yung mga nakaraan na pagsubok ko doon sa pagpapalit ng saligang batas, hindi po natutuloy yung pagpapalit. Kung mayroon man kagustuhan talaga yung tao na magpalit, dahil may perception po na nire-railroad yung proseso. To be very frank, na minamadali yung proseso. Yung saligang batas po natin, sa ayaw man o sa gusto natin, itinakda po talaga siya na hindi madali baguhin. At kaya po siya hindi madali baguhin ay kung titignan kasi yung karanasan natin sa ilalim ng diktadorya, madalas na ginamit yung pagpapalit ng saligang batas upang mapatagal sa pwesto si dating Pangulong Marcos. So, baked in na po, no? Malalim po yung distrust ng mamamayan doon sa proseso ng pagpapalit ng saligang batas. Yung isa po siguro na pwede natin gawin upang mapalapit lalo sa grassroots yung usapin na ito ay sundin po yung pinaka-konserbatibong interpretasyon ng pagpapalit ng saligang batas. Kung mayroon naman po kasi talagang kagustuhan sa lipunan, susuportahan po ng mamamayan iyon. Ngunit gaya ng mga panukala sa Kongreso sa nakaraan na pinaghirapan din naman talaga at nakabuti, kinakailangan po yung buy-in ng mamamayan, no? Yung acceptance ng mamamayan para sa success ng mga panukala na iyon. So yun po yung from the legal side, no? Yung mamumungkahi po namin, hindi po madali yung proseso at minsan nakakainip po siya. Pero baka kailangan po natin siya sundin ng tapat upang mapakita sa mamamayan na seryoso, in good faith yung ginagawa natin. Maraming salamat po.
Thank you.
Makakatulong po ba if at this early stage ay mag-invite na rin tayo ng mga representatives ng mga people's organization or youth organization para po sa simula pa lamang ay maramdaman nila nakasama sila sa proseso at importante din pong marinig ang boses nila.
Thank you, Congresswoman. Now, I'd like to ask our members if you have some questions for those. Yeah, Congresswoman Pandaligan.
Thank you very much, Mr. Chair. When we ask an opinion from our resource persons, particularly from the law deans, regarding this issue, because now we have a deadlock for a long time. We cannot pursue constitutional amendments because the Senate never agreed on the proposals coming from the House because of the ambiguity of Article 17, particularly the so-called first mode Constituent Assembly. We have passed a resolution here, for example, in the last Congress, March 2024, RHP number 7, that our good chairperson sponsored. However, of course, it didn't reach the Senate, or it reached the Senate, but it wasn't acted upon. So we have a deadlock because of the issue of voting. But I remember that in the hearings conducted last time, the so-called Bernas formula cropped up. Our own chairperson, in fact, stated that we can try the Bernas formula. But of course, it was criticized by some of the resource persons then as a violative of the Constitution. They allege that it is the fourth mode which is not allowed. However, personally, I believe that that isn't the fourth mode. That is just operationalizing the first mode. Because if we will not do that, then the first mode will be rendered nugatory. And I don't think the framers of the Constitution intended to craft a provision that will be negated. But because of their ambiguity, or because they neglected to clarify that, I think Congress has the right to try that so-called mode, wherein we will treat an amendment, a resolution, a proposed amendment, as an ordinary legislation. But of course, complying with the requisite 3/4 vote of both houses. So we vote 3/4 here, we send it to the Senate, they vote 3/4 also, assuming they will agree. Then we can have an amendment. That is my point, to break the deadlock and to render Article 17 operational. So maybe we can get some insights from our law deans here.
Dean Rani, about the comments of Congressman Panaligan.
The Bernas formula.
Mr. Chair, may I request, Your Honor, that he formulate very briefly paano yung formula mo?
According to Father Bernas, there is a way out. We treat the proposed amendment like an ordinary legislation. So the House will enact the proposal with the requisite 3/4 vote. The Senate will also enact the proposal with 3/4 vote. So we'll come up with a law, an act amending the Constitution. And then, of course, it will be submitted to the people. According to Father Bernas, that will solve the ambiguity. Of course, it will reach the Supreme Court, and that will be the opportunity for the Supreme Court to decide.
Well, that's actually the first mode, the Congressman, except that instead of voting jointly or meeting jointly, they would still be voting separately. I wouldn't have any problems with that. But if Senate maintains its adamant position against this, it will always stand in the way. You will never get the 3/4 that you need. You know, Congressman, one way I see out of it is if by sufficiently mobilizing the people and informing them so that the people are not used, people's initiative is used to amend that constitutional provision to make it clear that 3/4 is voting jointly, so that amendment is introduced by initiative, then you can break through the deadlock. The moment voting jointly has been placed there by initiative, the amendment can go ahead. Because if you wait for the Senate, ultimately, as our Vice Dean from UP says, if the lower house goes ahead and Senate does not agree, you will end up with the Supreme Court making a decision which brings in the whole counter-majoritarian difficulty in legal theory.
Father Aquino, from the UP, and we have your comment about the Bernas proposal.
So, Mr. Chair, subject to, I think we will take that suggestion and address it in the position paper. There might be a way to actually comply with the requirement that the House's vote, or the perceived requirement that the House vote separately. If to cite Justice Mendoza and his views on this, his view is that when Congress considers changes to the Constitution, it wears a different hat. It wears a constituent hat. And therefore, the perspective of Congress needs to also change when it considers it. And that's why a separate meeting is being proposed by Justice VB. But we'll look into this more deeply and see if there is a way to reconcile both Justice Mendoza's view and Father Bernes's view, and put that in our position paper.
Thank you, Assistant Dean Tamase. Now, I think Bernie, Chair Abante will now ask the question.
Mr. Chair, I'm sorry for coming in late because I was in, alam mo, multitasking tayo ngayon, di ba? The thing is this, no? We have been talking about constitutional change since the time of President Ramos until today. And always, the question is, wala sa timing, di ba? So, when is the time? Perhaps right now, what is happening to our country, it is time for us to have this constitutional change. Now, yung pinapaliwanag kaninang Constituent Assembly, pinag-usapan na ng husto yan eh. In the last Congresses, of which I'm a part of. Pinag-usapan na po yan at talagang matindi ang division dyan between the House and the Senate. And because of this, merong isang option sa ating Constitution. And the option is Constitutional Convention na pinanggit mo yung mamamayan, di ba? Yun namang ibang mga resource persons natin nung araw, binabanggit ang mamamayan, hindi naman sila nag-represent sa mamamayan. Ngayon, we would like the mamamayan to be represented. In the Constitutional Convention, all of the people will be represented. And this is the work of Congress. Nakalagay po dito, Article 16. 16 ba yan? Yan. 17. 16, di ba? 17, no? Ano nakalagay? The Congress shall provide for the implementation of the exercise of this right. It is the duty of Congress. Kaya pinag-uusapan po natin ngayon. Hindi naman yan pwedeng pag-usapan sa City Council. Hindi naman pwedeng pag-usapan yan sa board, provincial board. Hindi pwedeng pag-usapan yan sa barangay. Kaya pinag-uusapan natin sa National Congress. And I believe that all the people should realize that it is the mandate of Congress when it comes to the amendments of the Constitution, whether it be Constituent Assembly. Sinep na natin yan eh. Hindi na natin pinag-uusapan ngayon yan. Ang pinag-uusapan natin ngayon, Constitutional Convention. Hindi natin pinag-uusapan kung ano dapat pag-usapan pa dyan. We will not tell the would-be delegates of the convention what to do and what provision should be tackled. Bahala na sila dyan. Kung anong pag-usapan nila, bahala na sila. Whether it be economic provisions or political subdivisions, bahala na ang Constitutional Convention dyan. Although, ang ginagawa po natin dito, ito yung aking bill, an act constituting a constitutional convention to amend. Not anymore Congress telling the delegates, itong i-amend ninyo. Kayo na bahala dyan. Because we cannot even prevent them to what they're going to amend. Am I right? As long as it is the people that have actually voted for the delegates of the Constitutional Convention. Yun ang hanap natin. Let the people so decide.
Thank you, Chairman Abante. So, are there any more comments and questions from the members? Because then we will suspend to have our lunch. And then we will resume at 1 o'clock for the second group of resource persons. Wala na? So with that, this is no more questions from the members of the committee and members of Congress. We would like to thank all our resource persons for taking time to come to here to our hearing. Thank you very much. And we hope to get your resource persons to your papers, position papers, and we'll put a matrix and we will give it back to you so that you can also correct them if not properly encoded. So thank you very much. Let's have lunch. And then, so therefore, may I suspend the hearing of this committee? Suspended. Yeah, good afternoon, everyone. We're about to start with the second part of today's hearing of the Committee on Constitutional Amendments. And so let me first acknowledge the members who are present. We have authors, the two authors of two pending House bills and resolutions in the committee I refer to, and I'd like to welcome again Deputy Speaker Ronnie Puno and Chair Darin Abante. Can we now ask our COMSEC to be able to acknowledge our valued resource persons who are now with us? Thank you.
Thank you, Mr. Chairman. Good afternoon, Your Honors and our honored guests for this afternoon session. The first to arrive was Attorney Leonardo Camacho, well recommended by his Dean of Ateneo, Dean Hofilenia. He is an Ateneo Constitutional Law Professor and the Public Policy Advisor of the Tony Blair Institute for Global Change. We also have Attorney Joseph Manolo Rebano. He's the President of the Philippine Bar Association. And Dr. Clarita R. Carlos, our expert social scientist, still a professor of the UP Political Science. Then Attorney Alan G. Panolong, the National President of the IBP, Integrated Bar of the Philippines. Along with him is the Attorney Patrick Velez, the National Executive Director, and Attorney Manuel Joseph Ibanez III, National Director for Chapter Affairs. And still with us for the afternoon session, our long-staying and our resource person, Ms. Mariel Angela Soriano, of the Joint Foreign Chamber of Commerce.
Thank you, COMSEC. So again, welcome to our valued resource persons. I know most of you since way back, some of our put together, some are already the son of my mga ninong. So therefore, you just use my age. But anyway, so we welcome all of you. And so you have received our invitation. We are honored by your presence. And so we would be asking now your comments on the questions propounded. And I'd like to welcome our former COMELEC chairperson, Christian Monson. Please come. Yeah. Thank you very much, Chairman Christian Monson. Thank you for coming. Okay. Okay, so we would like now to start with Dr. Clarita Carlos. This is in the order, the accordance with coming in earlier. Okay. Professor Carlos, can we hear your comments on the questions propounded in our letter invitation?
Thank you very much for inviting me. I think this is the end.
The mic first, because.
Okay.
Yeah.
Is this better? Okay. So thank you very much. Good afternoon, everyone. I'm sure Congressman Rufus, you know that this is the end time you have invited me to this committee and relevant other committees. But I'm very glad to share my views in regard to the three questions which you sent to me to respond to. So I shall keep within the 4 to 5 minute limit that you have given each resource person. And maybe during the other interventions, I may put in my own views. In regard to whether we should revise the 1987 Constitution, it's really a yes. The Constitution is a living document. It is supposed to reflect the economic, political culture within which it is made to operate. Once you discover that it's no longer producing the kind of outcomes that you want to produce, then it's time to rethink, to reset, and to revise the Constitution. I have come out on record on many occasions in many fora that I don't want the Constitution to be fragmentally change. It's like you compare it to a human organism. The human organism is infirmed. It's infirmed in all organs of the body. And therefore, you cannot just pay attention to the spleen, to the heart, to the liver. You have to change everything. You change the economic provisions and then, Congressman Puno, haharangin ng political yan. I mean, I don't know. I know this is a minority view, but I hope we are going to rethink along that trajectory. In regard to the second question, the mode of changing it doesn't matter to me, actually. For as long as the electoral system is the same, first past the post system, doesn't matter whether it's con-con or con-us, but from the point of view of salapi, the money to be invested and the urgency of revising it, then let's go for the con-us. After all, to my now counting, I think you already have 9 drafts, Kong Rufus. Parang siyam na yan eh. So, kung sino man yung con-us or con-con, meron na silang pag-uumpisahan na siyam na drafts. They're not starting from nothing, no? So siyam na yon. Now on the third one, I'd like to talk a little bit more on that. Why shift to a federal system from a unitary system? A unitary system is only for a colonized setup. You know, where you want to control the extremities and strangle it until it's paralyzed. So every developed economy really would give more autonomy to its subnational units. So by all means, we should go federal. Of course, I can give at a later time to your committee the empirical evidence supporting my claim on this. The other one is to shift from a presidential to a parliamentary system. I'm as old as the Republic. I'm 80 years old already, and one of my legs is already in the grave, but the Republic is still a teenager trying to find out who it is. So why shift from presidential to parliamentary? Because again, if you keep on repeating the same framework, structure, and you are not getting the result that you desire, for God's sake, why not shift to another system? And again, there is a huge empirical evidence suggesting to you that if you shift to a parliamentary system, a lot of things will happen. Well, for example, your parties will be more disciplined because their political life will depend on how well they perform as a political party in the parliament. Secondly, I'm sure, Kong Rufus, alam mo na yung damdamin ko tungkol dyan sa tinamaan na party list na yan, which has been so bankrupt in its implementation. Unfortunately, hindi naman kayo nakinig sa amin at the time that I was laying out to you really what the party list system consists of. But yes, the time does not give, wala akong pisara dito, hindi ko ma-explain. But, you know, so these are the things that I stand for, to shift to a federal system, to shift to a parliamentary system, and to pay close attention to the party list. The underpinning philosophy here is this. You want to change people, it will take 3 generations, Congressman Puno, to change them. It's 90 years. You want to short-circuit the change the structure within which they perform, revise the Constitution. And when you change the structure within which they perform, you engender behavior change. Thank you.
Thank you very much. So very clear, the position to shift as a system of government from unitary to federal and the form from presidential to parliamentary and the party list system. Thank you, Dr. Carlos, once again. And now the next one will be in the order of appearance, Attorney Leonardo Camacho, over there from the Ateneo Law School.
Good afternoon, Honorable Chair and Honorable members of the House Committee. It's my privilege to share some thoughts and insights on some of the proposed amendments to the 1987 Constitution. First, on whether the existing environment is conducive for initiating constitutional change. And I believe that our friends from UP Law School earlier harped on the same matter. Even the most well-intentioned constitutional reform can fail if citizens harbor serious doubts on the process or the motivation behind constitutional change. And historical precedent is illustrative of this, with past efforts to amend the Constitution since the 1990s failing, regardless of their merits. So today, the social political context is again marked by some level of public skepticism, intensified by widely perceived systemic corruption in government. So in such an environment, we respectfully submit that pursuing constitutional change at this time may risk failure to secure that required social buy-in to successfully introduce enduring amendments to the Constitution. On the necessity of select proposed amendments to key economic provisions of the Constitution, we will submit our position paper to elaborate on our points. But we firstly recognize that the goal of attracting increased foreign investment as a means to enhance the economy is a very valid one. Nevertheless, it is our view that constitutional change is not the only and often not the decisive lever to drive economic growth. In many pivotal sectors of the economy, it is our view that the present constitutional and statutory frameworks already allow some level of meaningful participation by foreign entities. But just to highlight some of these points, with respect to the exploration, development, and utilization of natural resources, despite the nationalization provision under Article 12, Section 2, it is our view that the Constitution actually allows for a more permissive approach than what the plain text suggests. And this is most pronounced actually in the power sector, which is a major source of foreign investment and a significant pillar of the national economy. So to illustrate, the Supreme Court before has recognized the entry of foreign investors in the electric power industry, and in fact allowed foreign corporations to own and operate power plants such as hydroelectric power plants. And particularly with respect to renewable energy, which has become one of the strategic investment priorities of the government, existing legal frameworks have allowed 100% foreign participation in the sector. And as a result, in 2023, the Philippines actually achieved its status as a leader in renewable energy investment in the ASEAN region, despite the constitutional framework that we have. This applies as well with respect to mineral and oil and petroleum sectors, wherein the Constitution allows foreign participation in the large-scale exploration, development, and utilization of mineral and petroleum resources through foreign and technical assistance agreements or service contracts. And actually, to note, in October 2025, the DOE announced 8 new petroleum service contracts with several foreign entities having a value of $207 million, the largest one-time award in Philippine history. This substantial investment in the petroleum industry proceeded notwithstanding the nationality limitations embodied in the current constitution. With respect to the proposal authorizing Congress to ease restrictions on the allowable lease of agricultural public land, it may be noted that under the last paragraph of Article 12, Section 3, Congress already possesses the authority to determine the extent of agricultural lands that may be developed or leased. In fact, in September of this year, Congress passed RA 12252, which allows foreign investors to lease land for a period of 99 years. We have a comment as well on the Philippinization of certain areas of investment, wherein we note that under Article 12, Section 10, Congress has that power to determine areas of investment that may be excluded from the reservation. So, to cite some concrete examples, in 2013, Congress allowed the full entry of foreign banks with the passage of RA 10641 and allowing full ownership in investment houses and financing companies in 2015 with the passage of RA 10881. With respect to the constitutional limitation on the granting of franchises for the operation of public utilities to Filipino citizens or entities, it is also important to note that the Constitution, as it does not provide for a definition of public utility, grants the Congress plenary power to define the scope and coverage of public utility. And this is precisely what Congress did in 2022 when it passed RA 11659, which limited public utilities to certain select sectors. So in closing, Mr. Chair, honorable members, more than foreign equity restrictions, in-depth assessments on investor sentiment, such as the 2023 World Bank Enterprise Survey, have revealed that the real constraints in foreign investment lie in weak regulatory enforcement, expensive logistics and energy, uncertainty in local government regulations, slow permitting, systemic corruption, and the absence of a coherent long-term industrial strategy. Therefore, it is our respectful submission that policy reforms should instead prioritize governance-level reforms that directly address the country's true investment bottlenecks. For the lack of time, as for the other proposed amendments of the Constitution, we respectfully submit a position paper to outline our comments and insights. Thank you very much.
Thank you very much, Paniero, Leonardo Camacho. So I'd like to welcome Attorney Vicky Loanzon. How are you? No problem. Yeah, please be here. Join us. Yeah. Thank you. Yeah. Okay. Thank you very much. Yes. Okay, so next we'd like to hear, first we acknowledge our distinguished senior Associate Justice of the Supreme Court, Antonio Carpio. Welcome, sir. Welcome to the hearing. Thank you. And we would like to call on the President of the Philippine Bar Association, PBA, my god brother. The parents are my ninong-ninang in my wedding, Attorney Joseph Manolo Rebano. Please take the floor.
Good afternoon. Honorable members of Congress, thank you for this opportunity to speak at this critical matter. On the three questions. First, the Philippine Bar Association believes that the time has come to revisit our Constitution. For nearly 4 decades, it has served as the foundation of our democracy. But the Philippines of today faces realities far different from those of 1987. Globalization, digital transformation, climate challenges, and regional economic integration. These developments compel us to ask, does our Constitution remain fully responsive to the needs of our modern, competitive, and just nation? We believe, or PBA believes, that certain provisions, particularly those affecting economic development, mechanisms for accountability, require careful review and, where necessary, amendment. On the second question, PBA strongly favors a constitutional convention over Congress acting as a constituent assembly. Why? Because the credibility, integrity of this process is paramount. Convention allows for broader representation, bringing in voices from the private sector, civil society, and the legal profession. It ensures that reforms are not driven by short-term political interests, but by a long-term vision for national progress. However, this convention must have clear safeguards. Private sector participation to ensure inclusivity and economic foresight. Also, exclusion of current public officials and their immediate relatives to prevent politicization and conflicts of interest. The Constitution belongs to the people, not to those who hold power today. On the third question, if not, why not? We do not say no to reform. What we say no is any process that compromises integrity or public trust. If reforms is pursued without safeguards, or if it becomes a vehicle for political advantage, then it risks doing more harm than good. That is why the mode and the manner of reforms are as important as the reforms itself. Now we recognize that the full constitutional convention is a major undertaking. It requires time, resources, and consensus. That is why we also propose an alternative approach, one that may be more realistic in the short term. Similar to the United States, we can adopt a system of targeted amendments, addressing specific provisions that require urgent reform. These methods allow us to modernize our Constitution without rewriting the entire Charter, preserving stability while responding to pressing needs. In closing, as I know we have limited time, this is not merely a legal reform, it is a commitment to the future of our nation. The Constitution must remain a living document, one that evolves with the times while upholding the principles of democracy and justice. Let us approach this endeavor with wisdom, transparency, and a shared vision for a stronger, more accountable, and globally competitive Philippines. We as the PBA will submit our position paper with regards to the specific provisions, but we are supportive of the economic provisions allowing expanded foreign participation subject to control. Thank you very much, Chair.
Thank you very much again, Attorney Rebano. We will await your position paper. although your statement's already very clear, but you can expound on what you have said in this hearing. So now we go to the Integrated Bar of the Philippines, and I'd like to call my good friend, Attorney Alan Panolong, the National President, to be followed by Attorney Velez from Cagayan de Oro also, and Attorney Ibanez. Please proceed. Yeah. Before that, although I have recognized earlier, let me repeat my recognition of Attorney Vicky Luanzon, my co-alumnus, the professor now of De La Salle University. Thank you for your attendance.
With the permission of the members of the Honorable House and esteemed resource persons, may I proceed? Assalamualaikum warahmatullahi ta'ala wabarakatuh. Magandang hapon po sa inyong lahat. Ngayong hapon kaninyong tanan. Today, the Integrated Bar of the Philippines wants to address a critical question facing our nation. How should we improve the 1987 Philippine Constitution to meet the demands of our time? The answer we propose is clear. We should elect a constitutional convention to undertake a comprehensive revision rather than relying on a constituent assembly or people's initiative to make piecemeal amendments. Let me explain why this approach offers the best path forward for all Filipinos and what specific provisions urgently need attention. A constitutional convention is a specially elected body whose sole mandate is to review and revise the Constitution within a defined time frame. Unlike a constituent assembly, which consists of Congress itself proposing changes, a CONCON brings together fresh voices from diverse sectors: lawyers, educators, community leaders, workers, business owners, indigenous representatives, and youth advocates. This diversity is crucial because it ensures that the revision process is not dominated by the self-interest of the few, who might be tempted to write rules favoring themselves. The delegates to our CONCON have one job and one job only: to study, deliberate, and craft constitutional improvements. This full-time focus produces better, more thoughtful results than asking, with all due respect, busy legislators to juggle constitutional reform alongside their regular legislative duties. Moreover, a CONCON can be designed with built-in transparency, conduct public hearings, publish drafts, citizen consultations, and plain language explanations at every stage, which builds public trust and ensures that ordinary Filipinos understand what's being proposed and why. The question then arises, why pursue revision rather than simple amendment? The difference is fundamental. Amendment means changing one or two isolated provisions, like adjusting a term limit or modifying a specific provision. Revision, by contrast, involves a comprehensive rethinking of entire sections or structural elements of the Constitution, ensuring that all parts work together coherently. This distinction matters because piecemeal amendments can create contradictions, leave gaps, or generate new problems that were not anticipated when the changes were made in isolation. Revision allows us to fix the whole picture, addressing root cause rather than symptoms. It future-proofs our Constitution by anticipating challenges we'll face in the coming decades, like technological change, climate disruption, economic transformation, and evolving social norms, and brings in the flexibility needed to respond effectively. Well-drafted revisions also reduce legal ambiguity, which in turn minimizes court challenges, political disputes, and governance paralysis. When the Constitution speaks clearly and consistently, everyone, from government officials to ordinary citizens, can understand their rights and responsibilities without confusion. So what specific provisions need revising? Let me just outline some key areas that we thought needs thoughtful revision. First, consider the economic provisions found in Article 12. Current restrictions on foreign ownership in certain sectors may be too rigid or unclear.
creating uncertainty for investors and limiting economic opportunities. A careful revision can clarify which industries should welcome foreign investment to boost growth and employment, and which should remain protected to preserve Filipino ownership and national security. Second, local government and autonomy under Article 10 require attention. Many local government units, previously I was an elected board member of our district, complain that they lack sufficient power or resources to serve their communities effectively, while overlapping responsibilities between national and local levels create confusion and inefficiency. Division can strengthen fiscal autonomy for local units, clearly delineate the division of powers, and ensure that those closest to the people have the tools they need to govern well. Third, the political structure and term limits outlined in Article 6 and 7 deserve scrutiny also. Questions persist about whether our presidential system serves us optimally, whether the balance of power between the Senate and the House of Representatives is appropriate, and whether succession rules during crisis are sufficiently clear. Revision can examine these structural issues, potentially strengthening checks and balances and ensuring smooth transitions of power. Fourth, our electoral system under Article 6 and 9 that faces persistent challenges, including vote buying, vote, and unclear rules governing party list representation. A comprehensive vision can modernize voting procedures, incorporate technological safeguards against fraud, and clarify how representatives are chosen to ensure fair and credible elections. Fifth, while our Bill of Rights in Article 3 is robust, it could be strengthened and expanded to address contemporary concerns such as data privacy, freedom of information, environmental rights, and protections for vulnerable groups including women, children, indigenous peoples, and persons with disabilities. Revision allows us to align our constitutional protections with international human rights standards and emerging rights discourse. Six, it will now pave the way the definition of Article 2, Section 26 of the Philippine Constitution, which will now provide guidelines on the implementation of the political dynasty, the anti-political dynasty provision, ensuring accountability and good. Yes. 7, anti-corruption and accountability provisions are scattered throughout the current Constitution, and while they exist on paper, enforcement remains weak. A thoughtful revision can consolidate these provisions, strengthen sanctions, streamline accountability procedures, and make it genuinely harder for public officials to abuse power while making it easier for citizens and institutions to hold them accountable. Finally, which is the most usual issue, the transitional and amendment provisions in Article 17 contain ambiguities that have caused confusion and political conflict, particularly regarding whether Congress should vote jointly or separately when proposing amendments. Revision can clarify these procedures definitively, ensuring that future constitutional changes proceed smoothly, transparently, and without the procedural disputes that have paralyzed past reform efforts. How does a constitutional convention make this kind of comprehensive revision work better than other methods? The answer lies in several key advantages. First, expert input. CONCON delegates can invite economists, constitutional scholars, legal experts, even from other countries, and community representatives to provide evidence-based recommendation, ensuring that proposed revisions rest on solid research and comparative analysis rather than political expediency. Second, sector representation. Labor unions, farmers group, indigenous peoples organizations, women's coalition, youth movements, business associations, and civil society networks all receive seats at the table, ensuring that diverse perspectives shape the final product. Third, clear drafting. Professional legal drafters and constitutional experts work alongside delegates to ensure that every provision is precisely worded, internally consistent, and capable of standing up
to judicial scrutiny, thereby reducing future ambiguity and litigation. Fourth, public education. Throughout the deliberative process, the CONCON publishes plain language summaries, holds town halls, and uses media platforms to explain what's being proposed and why, enabling citizens to participate meaningfully in the national conversation about their fundamental law. The roadmap for achieving this revision through a constitutional convention is straightforward and practical. Step 1, Congress passes an enabling law that calls for a constitutional convention, clearly defining its scope, timeline, budget, and the procedures for electing delegates. Step 2, citizens across the country elect delegates from the regions and sectors, ensuring geographic and demographic diversity in the convention's composition. Step 3, delegates engage in structured deliberation over a fixed period, typically 12 to 18 months, studying constitutional issues, holding public hearing, consulting experts, debating alternatives, and drafting proposed revisions. Step 4, the convention publishes its proposed revised constitution for public review and comment, allowing citizens nationwide to examine the changes, ask questions, and voice concerns before finalization. And step 5, the proposed revisions are submitted to the Filipino people through a plebiscite where voters, armed with clear information and explanation, decide whether to adopt the revised constitution. If approved by the Filipino people, the revised constitution takes effect according to clearly defined transitional provision that ensure governmental continuity and stability. I'm getting in there. Why does this matter now at this moment in our history? The 1987 Constitution served us admirably in restoring democracy after authoritarian rule, protecting civil liberties, and establishing the framework for peaceful governance. 37 or 38 years have passed, and our circumstances have changed profoundly. We face economic challenges that demand clearer rules for investment and development. Governance issues require stronger accountability mechanisms and better defined institutional roles. New technologies raise questions about privacy, information, and digital rights that the framers of the 1987 could not have anticipated. Climate change threatens our communities in ways that require coordinated national and local responses. Our democratic institutions, while fundamentally sound, show signs of strain from ambiguity, overlap, and outdated provisions. We need a constitutional framework that speaks clearly to these realities, and constitutional convention offers the best path to achieve it. Unlike a constituent assembly, which risks self-dealing, or a people's initiative, which lacks the structure for careful deliberation, a CONCON combines democratic legitimacy and expert input, broad representation with focused mandate, and public participation with professional drafting. It produces not a patchwork of disconnected amendments, but a coherent revised constitution that Filipinos can understand, trust, live under for generations now. In conclusion, electing a constitutional convention to comprehensively revise our 1987 constitution represents the clearest, fairest, and most effective path forward for our nation. It brings fresh, diverse voices to the table rather than leaving constitutional reform to those already in power. It produces thoughtful, well-researched revisions rather than hasty, politically expedient amendments. It builds public trust through transparency and participation rather than breeding cynicism through backroom deals. It addresses the root causes of constitutional ambiguity and dysfunction rather than applying superficial fixes. And it gives us a modern, coherent fundamental law capable of guiding our republic through the challenges and opportunities of the 21st century. The choice before us is not merely procedural. It is a choice about what kind of democracy we want to be, how seriously we take our fundamental law, and whether we have the courage to build a constitutional framework worthy of the Filipino people's democratic aspirations. With that, I thank the honorable members of the committee for allowing us to share our observation. Thank you, Mr. Chair.
Thank you, IBP National President Alan Panolong. We'd like to hear now the National Executive Director from Cagayan de Oro, also Attorney Patrick Velez. Please proceed. And before that, let me just acknowledge Attorney, former Constitutional Commission Commissioner Christian Monsod, also former COMELEC Chair. Welcome to this hearing today. And also we'd like to welcome the representative and the national spokesperson of the College Editors Guild of the Philippines. We have Mr. Gabriel Lacerna. Thank you for honoring our invitation. Kindly proceed, Attorney Velez.
Good afternoon, Your Honors. For my part, it will be very brief since we will just be echoing what our IBP President has already stated. But we would just simply like to add that constitutions must always reflect social realities and political needs that are relevant to the changing times. So we agree that at this point in time, a constitutional convention would be the best mode available to us. We have to understand also that there are some portions of what is already there that are no longer relevant and should therefore be abrogated. Now, sad to say, if someone repeats the same mistakes over and over again, and he does so gleefully, then he will only be a fool, and we are not, and we should not be fools. In that case, Your Honor, may we just focus on at least two items which have been touched upon by our IBP President. The matter of political dynasties and the party list system is something that we should never shy away from in discussing and improving. These are very important items raised or that are found in the Constitution, but as stated earlier, the ambiguities must be provided now, otherwise it will persist. And on that note, Your Honor, let us state that our Constitution should be one that should reflect the changing mores of our times, such that it becomes a constitution for the people and by the people. That is all.
Thank you. Thank you, Panyero. Attorney Patrick Velez. Now we continue with the National Executive Director for Chapter Affairs, Attorney Manuel Ibanez III. Please take the floor.
Thank you and good afternoon, Mr. Chair and members of the committee. As our National Executive Director has re-echoed what our National President has said, I re-echo also what has already been stated to the Honorable Committee, but also add that, yes, also add, among other things, to update the direction that we adopt in updating our Constitution should also take into consideration that the world has really changed dramatically since 1987, and we have to consider matters involving personal data, online security, and the responsible use of new emergent technologies which actually affect our daily, everyday lives. And the constitutional review through the Constitutional Convention may even consider broad principles that protect citizens' rights with respect to these technologies. Maybe to end, regardless of which proposal and however which way that we go about this, I believe that the Integrated Bar of the Philippines, under the leadership of our National President, would urge the certain principles be followed or guided, which should guide the process. First and foremost, fidelity to the Constitution and, of course, the rule of law, the continued protection of fundamental rights and freedoms, the preservation of checks and balances, and, of course, broad public participation with the end goal of strengthening access to justice. Our Constitution, I believe all of us agree, is a reflection of our values, aspirations, and safeguards. And any discussion on it, such as the one that we're having now with this honorable committee, and we're thankful, deserves patience, seriousness, and exclusiveness. I speak for the IBP when we say that we are honored to be able to contribute some insight in this very important conversation, and we remain ready to assist this honorable committee to ensure that any constitutional development strengthens rather than weakens the rule of law and administration of justice. In that regard, Your Honor, we'd also, if we be allowed an opportunity, we would also like to submit a position paper outlining probably the details of what we've already echoed to this committee. Thank you.
Thank you, Panyero, Attorney Ibanez. And certainly for our resource persons this afternoon, we would appreciate if you'll submit position papers. We're coming out with a matrix. Yes, this morning we had about 20 also resource persons. We will come out with a matrix and we give back to you. And this will likewise be given to the committee members for their decision on how to go forward with all the pending resolutions and bills on constitutional proposals. Thank you very much. Now, we would like to hear the Honorable former COMELEC Chair and former Constitutional Commission Commissioner, Attorney Christian Monsod. Sir.
Good afternoon, sir. Thank you. Thank you very much for inviting me to this hearing on charter change. As for the purpose of the amendments or revisions, I quote the President, Mr. Marcos, interview last January 3rd, where he said the 1987 Constitution was not written for a globalized world. We have to adjust it so that we can increase the economic activity in the Philippines and we can attract more foreign investments. There we go again, foreign direct investment. This is the same president who a year ago said, for me, all these things being talked about, we can do without changing the Constitution. We've heard him several times say opposite things. This was one of them. The president is the chairman of NEDA, which came out in September 22 with the Philippine Development Plan approved by the president that states that the country is open for business with the enactment of Republic Act 11647 on retail trade, Republic Act 11659 that opened the door for 100% foreign-owned companies in telecommunications and transportation and in renewable energy. And then there is the EPIRA of 2001, which allows 100% foreign ownership in power generation. As for land, lease is allowed for 50 years, even 70 years on government land, even if the foreign chambers of commerce themselves admitted that opening land for foreign investment will raise the price beyond the reach of the poor. As for mining, it is allowed 100% ownership, the Bugal case, in partnership with government under Article 12, Section 2. And then, of course, there is the approval of the Regional Comprehensive Economic Partnership. There is absolutely no mention of any charter change in the Philippine Development Plan 2023 to 2028 to fulfill its goals and programs. The same with the Philippine Development Plan under Duterte 2016 to 2022. No mention at all of the need for charter change to achieve the goals of the Philippine Development Plan. Moreover, in none of the 73 billion of investment pledges secured by the President in his trips abroad, there is not one where there is a condition for charter change. And there is the example of the Japanese manufacturing companies leaving China about 4 years ago, who put the Philippines as destination behind Indonesia, Thailand, and Vietnam. When the Japanese Chamber of Commerce was asked why we were number 4, since manufacturing in our constitution is allowed 100% foreign ownership. There was much discussion of the pros and cons, but but also what came out was that finally the factor against their coming here was what they call country 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 situation or country image. And they said primarily that was corruption, including transactional legislation, which would open the door wider by the insertion of that phrase, unless otherwise provided by law, unquote, in the economic provisions of which corrupt politicians and greedy big business are very adept. Clearly, there is no need or requirement for charter change in the Philippine Development Plan, nor the investment pledges to the President. What then is the purpose of a convention, or for that matter, a constituent assembly? I cannot argue the proponents of Chacha often blame the Constitution for our being the laggards in our part of the world on growth, poverty reduction, and increasing inequality, and for being the hindrance to our need for foreign direct investment. On the contrary, I would argue that it is not the Constitution that needs revision. Maybe the Philippine Development Plan needs a revision. In addition, it has good programs on addressing growth and poverty, and it's correct in not proposing charter change. But it has no programs to address the social, economic, and political inequalities of a feudalistic society of political dynasties in all of its 400 pages. Perhaps it is against the interests of those in power. Social justice does not appear in big terms in the 8th socio-economic agenda of President Bongbong Marcos. I will also answer the question that begs to be asked. Is foreign direct investment really that critical to our development that merits changing our Constitution? So may I have your indulgence to talk briefly about the Constitution they want to change? Because surveys show that 73% of our people know nothing or very little about it. And we are told that an ignorant people can never remain a free people because the democracy cannot survive with civic ignorance. So if I may just cite some parts of the 1977 Constitution. Before the Commission started writing, we went around the country to listen to the people. They said they preferred the stability of familiar structures, a democratic, representative, presidential system with checks and balances and separation of powers. And overwhelmingly, the people wanted the power to directly elect the president. Where is the federalism here? There are a number of provisions of the 1935-1973 constitutions that are retained in the 1987 Constitution. But the 1987 Constitution innovated with 3 central themes. First, the heart of the Constitution is social justice, with the poor as a center of development, as enunciated by the President of the Constitutional Commission, former Justice Cecilia Muñoz Palma. Hence, the new Article 13 on social justice to address not only mass poverty, but also the gross social, economic, and political inequalities that is rooted in a feudalistic system of dynastic families that has been impervious to change for generations, with the corruption that goes with it. The compelling principle is encapsulated, if you want it, in one sentence, one phrase: by equitably diffusing wealth and political power for the common good. Second, never again to any authoritarian government. Hence, the strict limitations and conditions for declaring martial law, and new provisions on the Bill of Rights, and a Commission on Human Rights to protect citizens against abuses by the state. Third, the national destiny must firmly and safely rest on Filipinos themselves. Never again amendments similar to the 1935 Constitution that gave Americans equal rights to our patrimony, where even our exchange rate after independence could not be changed without the approval of the United States government, which resulted, as you know, in a foreign exchange crisis of the early 50s. Before the commission started writing, we went around the country to listen to the people. They said they preferred the stability of familiar structures, a democratic representative, of course, presidential system, and overwhelmingly, as I said, to direct the election power directly to elect the president. There are certain provisions in the 1935 and 1937 constitutions that are retained in the 1987 constitutions. But the 1987 constitution innovated with three central themes. The first, the heart of the Constitution is social justice, with the poor as a center of development. Hence, the new article on Article 13 to address not only mass poverty, but gross economic, political inequalities that is rooted in a feudalistic system with the corruption. Second, never again to any authoritarian government. Hence, the strict restrictions and conditions on declaring martial law, and the new provisions in the Bill of Rights and Commission on Human Rights. Third, the national destiny must surely rest in the hearts of the Filipinos. The 1987 Constitution also cut the umbilical cord of the 1935 and 1937 Constitutions to the United States Constitution. The U.S. Constitution gives primacy to civil and political rights because it is a country of immigrants who only started from the same position, and they only wanted to get out of autocracy. Hence, the emphasis in the United States on individual rights and market economy. Our Constitution gives social and economic rights equal primacy with civil and political rights, because we are a country of inequalities from the colonial days to the present, where the starting positions of the rich and the poor are not equal. Social justice is about the adjustment of starting positions, because we foster the market competition with such development paradigms as it is not enough to provide equality, opportunity, and fair process. And we are always told that rising waters raised all boats, forgetting that many boats are crammed with people without food amid the luxury yachts of the rich, like Mr. Ko. That is why social justice provisions are ever included in the article on the economy. Under Article 12, Section 6 of the economy, the use of property bears a social function, and all economic agents shall contribute to the common good, subject to the duty of the state to promote distributive justice where the common good so demands. Without the vision of a new social order, the state should engage in income distribution program, primarily quality education and quality healthcare, and 4 asset distribution programs for the poorest of the poor. What are these? Agrarian reform, urban land reform and housing, ancestral domain, and fisheries reform. How can the young of the poor compete for career and business opportunities with children of the rich when the quality of education of their education and health are not the same? And I think it is in the budget that they took away a lot of money from health and education. With regard to the asset reform programs, CARP, ancestral domain, and fishery, all of these programs are underperforming and underfunded. For example, agrarian reform was supposed to have 225 billion over 20 years. They gave only 175. Or they put loopholes in the law, such as a distribution of shares instead of land in Hacienda Luisita. Fortunately, we went to the Supreme Court and we won a decision of 14-0 in favor of the farmers of Hacienda Luisita. 3 days ago, I got a call from them that they have another problem, that Agrarian Reform Department decided against them on 321 hectares of land that are supposed to be included in their land. And urban land reform and housing. The LGUs, the local governments, were able to sell their lands to rich land developers with commissions, of course, instead of using them for housing for the poor, to save them 4 hours of heavy traffic to go to work. Then there is the declining harvest of municipal fishermen because their fishing grounds are not protected against large-scale fishing, some owned by politicians. The recent case of Mercidar, in which the Supreme Court allowed large-scale fishing in municipal powers, we now have a petition in the Supreme Court, Cardinal David and I, questioning this decision and asking for a reconsideration. We found out that the chairman of Mercidar Fishing is a lady, and her husband is the present chairman of the Commission on Audit. No wonder she has influence. Our indigenous peoples used to own all the land, but were driven to higher ground by our colonial masters in complicity with cacique landowners, where they are now facing mining companies who are not only given access to minerals without any value given to raw materials. Look at the laws on what the share of government is. There is none for contributing the ore, but I've given it to mining companies who also have forestry and water rights. The proposed mining reform bills on mining were killed at the committee, both under the Pinoy and Duterte administration.
With due respect, Chairperson, you still have how many pages? Because we would like, if you can wind up, because all those in your position paper will be included in the matrix.
I'll send it. I'll send a formal one. I'll just close it. May. Where do we go from here, sir? Well, I think we go from here and we'll have to ask Congress. We face, what problems do we face? We face the feudalistic system of dynastic families to attend to. We have a Supreme Court that is not always independent. We also sorry. We also have the problem of possible coup attempts. I can assure you from what I hear from my friends that there will be none. There will not be a coup attempt to dispose the president. And of course, I'd like to, sorry. I'd like to end it, like to ask this Congress, please note that there is no single reference or mention of any amendment to revision as a means to achieve any of these projects. I would just like to object to the Constitutional Convention, which attempts to assure the people that it will be independent. The delegates should be appointed, will be elected by district. And there is a provision that government officials cannot run. Right? So, of course, the existing congressman cannot be in the Constitutional Convention. But their brothers, sisters, wife, and so on, cousins can, because there is no anti-dynasty provision. So I can assure you, sir, that the people will not like it. And you should think twice about changing the Constitution, and especially by a Constitutional Convention. Thank you.
Thank you, Chairman Monsod, for those comments and insights. It will help the committee finally decide on what to do with all the pending resolutions and bills proposing for amendments or revision of the Constitution, either to Constituent Assembly or Constitutional Convention. Thank you so much. We will appreciate if you can give your position paper, so it will be included in the matrix. It will be considered by all members of this committee and give copies also to all the resource persons. Thank you very much, Chairman. Now, before we proceed, I'd just like to acknowledge the presence of our Deputy Majority Leader from the 3rd District of Leyte, the Honorable Ana Victoria Viroso Tuason. Thank you very much for being here with us. And we have also here Congressman Nico Daza from Samar. We welcome you. And then we also have with us another resource person. We have Mr. Blake Barrios, Director of the Union of Local Authorities in the Philippines, ULA. Thank you for coming. Now it is my time to call our distinguished former Senior Associate Justice, Antonio Carpio. You have the floor, sir.
Thank you, Your Honors. Thank you for inviting me here this afternoon. I have read your House Bill number 5870, and I wholeheartedly endorse this House Bill for the following reasons. First, it calls for a constitutional convention, and a constitutional convention will avoid the divisive issue of a constituent assembly, because we still do not know whether the voting should be separate or joint. and this will have to go to the Supreme Court, and it will take time. And I think the nation will be happy with the Constitutional Convention. So I think that is the right approach. Second, the delegates will be elected by region. This is good because this will avoid the issue of political dynasties. Because if the election is by district, then you can be assured that it will be the political dynasty will be an issue and the people will object to that. So this is a very good way of addressing the issue of political dynasties by making the delegates elected by region. And 150 maximum delegates would be ideal, with three delegates as a minimum per region. And the rest of the delegates will be elected in proportion to their population. So I think that would be good. I agree with that. And well, lastly, you have the usual disqualification for members of the convention from running in the next succeeding election after the ratification. So I think this is ideal. I would gladly and wholeheartedly recommend House Bill 5872. On a personal note, I am for a shift to a parliamentary system because the present presidential system is just too impractical already. To run for president, you need at least 5 billion pesos. And to generate this amount of campaign funds, you will have to promise everything to your supporters. You will make commitments. So on day one of your presidency, you will be hamstrung, you will be tied down with these commitments. So I think we can avoid that through a parliamentary system. So that is all, Mr. Chair, Your Honors. I will be brief. Thank you.
Thank you for your comments and insights on the present House Bill 5870. Thank you very much. And your comment about having a constitutional convention and your views on having a parliamentary system of government. Thank you very much. Next would be Attorney Vicky Lonson, Professor de La Salle University.
Thank you, Mr. Chair. We have a short paper. We have submitted it to the committee secretary. Let me read what we have agreed with the other professors of the Political Law Department of De La Salle University. Okay, thank you, sir. So let me read from our agreement. The Constitution has provided a stable framework for governance for nearly 40 years. While it is natural and commendable to seek improvements where necessary, we believe that the timing and context of such significant changes deserve careful reflection. The latter half of the presidential term in particular often brings heightened political activity and public scrutiny. In this environment, even well-intentioned initiatives may be subject to misinterpretation or skepticism regarding their motives. Recent political developments have further highlighted the importance of public trust in the amendment process. By approaching constitutional reform with patience and broad consultation, Congress can reinforce its reputation for prudence and inclusivity. We thus propose that any constitutional change be considered not in the remainder of the term of the current president, but at the beginning of the term of the next president. To ensure that any amendments are both effective and widely supported, we suggest that Congress consider establishing a multi-sectoral advisory group. This group can consolidate previous studies and recommendations on charter change, providing a comprehensive and balanced foundation for future deliberations. Such an approach would contribute and accept opinions of all stakeholders and foster a spirit of national unity. Should there be, however, consensus on the need for urgent constitutional modifications during the current term, we respectfully propose that these be limited to areas where there is broad agreement on the issue of political dynasties. Introduce a clause that clearly defines the prohibition on political dynasties unless this is addressed by a bill under consideration and the bill has not been ratified into law. Amendment procedures clarify Article 7, Section 1, Paragraph 1 to require separate voting by both houses of Congress as practiced under the 1935 Constitution. This would help ensure clarity and fairness in the amendment or revision process should we take a constituent assembly as an option. We commend the members of Congress for their dedication to constitutional improvement and their willingness to engage in open dialogue. By considering the timing and scope of amendments and fostering inclusive consultation, Congress can further strengthen public trust and ensure that any changes serve the nation's enduring interests. We remain at your disposal, sir. The full force of the Department of Political Law of De La Salle University is at your disposal. Thank you, sir.
Thank you, Panyera, Attorney Vicky Loanzon. Thank you for your views, especially on the timing that you have stated on when to call for a constitutional convention. So now we'd like to, thank you, and we now go to the spokesman, national spokesperson of the College Editors Guild of the Philippines, CEGP, Mr. Gabriel Lacerna. Thank you. Yeah, please take the floor.
Good afternoon, Honorable Chair and distinguished guests. I am Gabriel Lacerna, the national spokesperson of the College Editors Guild of the Philippines, representing today's youth. For today, the country saw one of the worst corruption schemes erupt after the President's State of the Nation address last July 2025. Flood control projects became the center of public attention as monsoon rain submerged communities in deep flooding while corrupt officials drenched 118.5 billion pesos from public coffers packed in suitcases since 2023. This compounds existing issues with anomalous public spending which remain unaccounted for, such as the utilization of the confidential and intelligence funds, inaccessible universal healthcare services, short-change education funding across all levels, and other crucial welfare programs that would have addressed widespread poverty, unemployment, and education losses. And these damages indeed raise the need to reassess the viability of the frameworks that shape government policy, public services, and national development. Desperate measures must be taken if this administration is serious in heeding public outcry against corruption and impunity. However, the College Editors Guild of the Philippines asserts that the charter change, which this floor is consulting today, we believe that it will not solve the country's woes. This country needs more than a revamp of constitutional provisions. The Marcos administration must first resolve systemic corruption and inefficient public service before it tinkers with constitutional provisions. We reject all current attempts to revise the 1987 Constitution and its standing provisions at this juncture. The prevailing socio-political climate will only lean towards the interest of the disintegrating political unions and not in favor of the marginalized Filipinos, such as the youth. At the height of such corruption scandals and administrative incompetence, Chacha will only become a conduit for further exploitation of the rotting socioeconomic structures and the perpetuation of systemic inequality by vested interest, it becomes an opportunistic move against the people's call for genuine reforms and community-driven development. Revisions to certain articles of the highest law of the land will not appease growing discontent on the results of the investigation on involved officials, some of which have escaped accountability. And it will not help recover the trillion of public funds squandered away in casinos, luxury cars, and other lavish expenses incurred while the majority of Filipinos scramble for scraps of financial aid, insecure employment, and rising cost of living. We particularly take note of the proposed inclusions in the provisions under Articles 10, 14, and 16. These are the provisions stated for amendments in the resolutions of both houses, number 1, fielded by Ako Bicol Party List, and 3, fielded by District Representative Richard Gomez. Revisions of the aforementioned economic provisions perverts legislative authority and subjects the state of our national economy and patrimony to exploitation. The clause, unless otherwise provided by law, steers away from the obligation of the Constitution to protect its citizens from disadvantageous competition from foreign firms. It opens the national economy and public economic interests to exploitation. Previous charter change deliberations in the lower house plenary reveal how hasty and idealist are the propositions for foreign ownership of firms, industries, agricultural processes and products, public services, education institutions, media outfits, and advertising and public relation firms, creating special exemptions crafted as unless otherwise provided by law opens a can of worms. This is why in what we have submitted, the position paper, we have pointed out 4 major points in the revising such bills. First is the country does not fully benefit economically from industries and sectors open to foreign firms and investments. Second, we have poor policies and programs that will not help small-scale industries and institutions keep up with foreign competition. Third, opening the media and communication industry to foreign ownership subjects community journalism and the creative industry to commercialization and attacks on our integrity. And fourth, minimum wager Filipinos and poverty-stricken families continue to bear piling consumer taxes while the government deregulates multinational and transnational corporations, big companies through tax holidays, exemptions, and discounts. The proposals for constitutional convention, particularly House Bill 3068 by Representative Bienvenido Abante Jr. and 5870 by Representative Rolando Puno, and House Resolution number 460 do not even account for the youth's participation in the lawmaking process itself. These only provide for the formation of a delegation, but lack concrete guidelines for a more concrete and grounded composition of the representatives of the people who will kickstart it. On the other hand, the resolution of both houses, number 2, or the proposal to the lowering the age requirement for the positions of president, vice president, and senator falls short of realizing the objective of youth participation in governance, supposedly modeled after the United States and other democracies. It fails to account for the situation of youth leadership in communities. Data from the ground will show that young members of political dynasties, relatives up to the third degree of consanguinity, were the majority of the members of Sangguniang Kabataan Councils and even rank and file posts in local government offices and agencies. proposed reforms to strengthen youth representation are masked attempts to perpetuate the control of political dynasties in all branches of the government. It does not address the gaps in grassroots leadership and people-driven development. The upper echelons of the state may see changes, but it will temporary and short-handed if its local representatives still come from the same set of names that robbed opportunities for leaders born and raised by their communities. For our genuine proposals, ultimately, even if the goal of crafting precise, plain, and appropriate diction for the Constitution is achieved, the current socio-political conditions will pin down its purpose and viability. The Guild, having laid down its grounds for opposition, presents to the House of Representatives its alternatives for the forwarded proposals for the Constitutional Convention. The Philippines needs genuine agrarian reform, national industrialization, protection of its natural resources to ensure sustainable development, recognition of the rights of the working masses, efficient use of capital for development, and an independent foreign policy. These programs require a strong role for the state, a strong state. What is not needed for this development is the charter change, nor the Marcos Jr. government's attempt to push it. Genuine national development in the Philippines hinges upon implementing these alternatives, even upholding the rights of the youth and the working masses, especially for social justice. Achieving these vital programs necessitates a strong and active role for the state. What the Philippines does not need for development, however, is such proposal of charter change. The 1987 Constitution's foreign investment restrictions are time-honored and in no way obsolete. This is why so many other economies in the region still have foreign equity restrictions in ordinary law. Unlike in other countries, the drafters had the boldness and confidence to hard-code these in the Constitution. What they didn't foresee, though, is the determination of economic charter change and their creativity in using ordinary laws to bypass the charter. And these foreign investment restrictions embedded in the 1987 Constitution are enduring and remain relevant. This is evidenced by the fact that many regional economies maintain similar foreign equity limitations through ordinary legislation. The framers of the Philippine Constitution uniquely demonstrated boldness and confidence by enshrining these provisions directly in the fundamental law. Their oversight, however, was perhaps not anticipating the persistent resolve of proponents of economic charter change and their inventive use of ordinary statutes to circumvent the constitutional mandates. Thank you.
Thank you, Mr. Lacerna, for stating the position of the College Editors Guild of the Philippines. Before we proceed, we would like to acknowledge the presence of the Honorable Rachel Del Mar, the representative of the 1st District, City of Cebu, and also our Deputy Majority Leader and our member of the committee, the Honorable Arnan Panaligan over there. Thank you for your presence. Now we will finally hear the position of the ULAP, the Union of Local Authorities in the Philippines. Mr. Blake Barrios is recognized.
Yes, Mr. Chair, thank you and good afternoon. First, we thank the committee for inviting the Union of Local Authorities of the Philippines to this deliberation. At the outset, sir, 2 caveats. First, all the official positions of the Union of Local Authorities of the Philippines have to undergo approval by its National Executive Board. We will be having our National Executive Board meeting tomorrow, so we will bring up this matter to the National Executive Board. After then, we shall submit our official position paper to the committee. Second, our comments will be focused mainly on provisions pertaining to local government units. For context, in 2024, ULAP said that if the Constitution is to be reviewed, we hope that the local government units and the leagues will be meaningfully consulted throughout the process. We believe that that request still stands, and however, whether or not there is a broad grassroots clamor for amendments is precisely why we are now canvassing the feedback of our member leagues. We will report those results to the committee. Over the years, several proposals from local officials and leagues have surfaced, including, among others, changes in national tax allotment and intergovernmental transfers or shares in national wealth and term limit adjustments. But these are proposals that we will have to look at, review, and further substantiate for now. Substantively, one major concern has emerged from our reform work on devolution, local economic development, health, disaster management, and social protection: the need to strengthen the constitutional guarantee for local autonomy. Article 10, Section 2 states that territorial and political subdivisions shall enjoy local autonomy. In recent jurisprudence, however, the practical space for local choice has narrowed. In the Mercidar Fishing Corporation ruling of the Supreme Court upheld a lower court ruling that invalidated key fisheries code provisions reserving municipal waters to municipal fishers, which effectively opened municipal waters to commercial fishing, with significant implications for coastal LGUs' regulatory reach and for small-scale or artisanal fisher folks. A motion for reconsideration has been filed, but the message to LGUs is already stark. National baselines can displace local preference unless the Constitution speaks more clearly. In ULAP's position paper that it submitted to the Supreme Court, we said that the case cannot just be summarily dismissed, and we reiterated the need to uphold local autonomy as well as the legal basis for the buffer zone, that is the 15-kilometer municipal water delineation. In another case decided recently by the Supreme Court involving the province of Occidental Mindoro and Agusan Petroleum and Mineral Corporation, the Supreme Court struck down a province-wide ban on large-scale mining, holding that blanket prohibitions contradict the Philippine Mining Act and cannot override national policy. The court clarified that LGUs may evaluate projects case by case, but cannot impose an absolute 25-year ban. This matters to us because autonomy is not abstraction. It is the operating space that lets local government units respond to differentiated risks and align land use, health, and social protection with real conditions on the ground. When autonomy is vague, preemption fills the vacuum. Mandates and personal impositions follow without commensurate financing, and accountability blurs national intent and local capacity. However, ULAP also acknowledges that the constitutional amendment is not indispensable to achieve this. If the Constitution is to be amendment, ULAP proposes that the Congress considers clarifying and deepening the autonomy clause, especially in line with current direction towards devolution, because as we know, national government has now moved towards devolution, for example, of school building constructions, devolution of some infrastructure works. And so if that is the direction that the national government is pursuing, then there is really a need for us to also strengthen local autonomy. In that sense, we respectfully recommend looking at the Article 10 to make autonomy genuine and meaningful, anchored on subsidiarity and cooperation. For instance, adding a clear statement rule on preemption. National laws may displace local ordinances only through an express statement of preemption and only when necessary to address a demonstrable national interest. Relative to local autonomy, of course, our LGUs will also find value in inserting a clause prohibiting the imposition upon LGUs of new functions, standards, or personal requirements without commensurate or verifiable funding sources, or what we call unfunded mandates. The national mandate must identify its financing mechanism and transition period. To be clear, these are among the options we are studying. Some goals may also be achieved without amending the Constitution through a calibrated package of organic local government code revision or amendment, targeted revisions to sectoral statutes, stronger intergovernmental relation mechanisms, and budget and administrative safeguards against unfunded mandates. We will submit our ranked board-approved recommendations after the National Executive Board meeting of the ULAP tomorrow. Thank you.
Okay, thank you very much. Mr. Barrios for stating the position of ULAP in this hearing. Now, we now would like to state that we have finished listening to our resource persons. Let me just state that for those who are not able to come, they have sent letters or called the committee that they will be submitting their position papers on December, supposed to be 8, but it's holiday, December 9. And then we will prepare the matrix for everyone, especially for the members, to make decisions on how to move forward. At this point, we call on our members, the House members, to propound their questions. So I will start with Chairman Benny Abante.
Thank you, Mr. Chair. One of the things I heard from one of our resource speakers is that there is no need to revise the 1987 Constitution. But upon hearing the comments and the statements of the resource speakers, I have seen there are many infirmities of the 1987 Constitution. And also, thereby being explained here that there are a lot of provisions that ought to be included in the Constitution, of which perhaps we could be able to have today. So therefore, the 1987 Constitution should also be revised in some areas. In fact, our resource speaker that said that there is no need for revision even mentioned to us human rights. And I am the chairman of the Committee on Human Rights in the Congress. And I'm so glad he mentioned that. Social provisions, poverty. The thing is, the 1987 Constitution is a good Constitution. In fact, I'm following it. Being a man that believes in following the Constitution, I am abiding by the Constitution. But our Constitution is made by man. Man is not perfect. Marami pa ring nakakalimutan tayong ilagay. For example, you made mention of the anti-dynasty bill na hindi na kinakailangan pag-usapan dito sa Kongreso, pero pwede pag-usapan sa Constitutional Convention yan. Alright? Pinag-usapan din natin dito yung tinatawag, you made mention about the anti-dynasty. Yung dynasty, mangyayari din yan sa pagpili natin ng mga delegates. So therefore, kung yan, iniisip natin, we welcome the amendments to the call of Congress for a constitutional convention. So that hindi pwedeng maging delegado ang mga kamag-anak ng mga politiko. Pwede natin pag-usapan yan. Pwede natin ilagay yan. Pwede natin i-amend yan. You see that? That's the reason why ang amin ditong ginawa, Mr. Chair, is that we are just calling for a constitutional convention sapagkat hindi na pinag-uusapan dito ang CONAS. Di ba? I mean, ako naniniwala din ako, CONAS can be biased. Constituent Assembly can be biased. Can be something that would not be welcomed by the people. Yet, the Constitutional Convention, for example, like the 1987 Constitution, number 1, the Constitutional Convention delegates were not elected. Please take note. They were not elected by the people. Oh, ito, i-elect ng tao eh. Number 2, the 1987 Constitution was promulgated during the revolutionary government of the president. Not when democracy is working now. Hindi nangyari yun nung araw. Ngayon, democracy is working. Oh, ngayon, pinag-uusapan natin, for example, Mr. Lacerna spoke of the flood control projects. I believe that the constitution that will be promulgated this time by the Constitutional Convention can address corruption, can address the flood control corruptions happening right now. And by the way, if you would like to make an amendment to the Constitution of the Constitutional Convention as far as including the youth sector is concerned, we welcome that amendment, Mr. Chair. So, ito lamang ang masasabi ko for a while. That's the reason why, Attorney Monsod, although I accept all of what you said, and I would like to thank you for mentioning human rights and social justice. Kailangan po natin yun eh. You mentioned about the anti-dynasty bill. Ako, ipaglalaban ko din po yan na hindi kayo na kailangan. You see that? But we need to have this revision. So please, siguro, you could be able to explain further, Attorney Monsod, why is it that there is no need to revise the 1987 Constitution when you heard all of the resource speakers telling us that there's a lot of provisions that can be included in the Constitution if we ever have a constitutional convention today. Attorney Monsod, I'm asking a question, please, to Attorney Monsod.
Chairman Monsod, there is a question from Chairman Abante to you. Can you state the question again?
Can you please explain further why you said that there is no need to revise the 1987 Constitution? Do you believe that the 1987 Constitution is complete and there are no infirmities in it?
There should be some revisions, but not a new constitution or a total change in the constitution. Because let's put it this way. Today, the people feel that they have been lied to by government. That's why you have all kinds of
Mr. Chair,
corruption.
may I interject? Mr. Chair,
Yes, also have the chair.
baka makalimutan ko eh, no? You said that the people have been lied to. The people has always been lied to. Attorney Monsod, since the 1987 Constitution, the people has always been lied to. Now you tell me, where was the people not lied to?
Well,
Attorney Monsod, tell me, when was the people not lied to? Oh, even before the 1987 Constitution, you were attacking the former President Marcos' rule. Oh, were the people not lied to during the time of President Marcos Sr.?
well,
Or were they lied to?
well, as I was saying, the 1987 Constitution, EDSA was two things. One is to restore democracy, and two is a new social order. Now, every administration since EDSA have failed in that promise. Every administration. And I'm not saying one or the other. But what has been happening here since Duterte's time up to now, because before them, certainly there was corruption. That's the reason why over 50 years, from 1960 to 1910, 50 years. In 1910, we were the leaders in Asia in per capita income. Leaders below us, Thailand, Malaysia, Indonesia, and so on and so forth. 50 years later, we're at the bottom of per capita income. Why is that? Why is that? Because I'm sorry to say, our governments have been controlled by a feudalistic system of government. And until we dismantle that, and we have a new generation of leaders who know how it is to be poor, we will not have real democracy. Now, how can we do that? How can we make sure, how can we change things? The signs are there, right? Look at what happened in the last few elections. That number one, many dynasties are no longer in power. Number two, there were a group, many young mayors in the country who were voted for their competence and their incorruptibility. And we know that, right? Now, also, what happened is those during the pandemic, those who had the means helped those who were in need. Now, what does this show us? Today, we're always looking at, who can be the angel of hope that's going to transform our country from above. Because as you said, and I agree with you, all the administrations have failed. So here we are always talking about sino kaya kandidato na presidente, assuming that, oh boy, transformation from above down. Transformation in a country should be from the bottom up. If you look at what happened during the pandemic, how new young politicians are being elected and so on, there are already signs from the people. That's why, sir, to me, the most important elections in this country is the barangay elections. And we on the elite, should go around, organize the poor in this country and say, you have the sovereign power. How much of 54% or something of the voters are from the poor? They should use that power. Because to me, that's where we should start. I agree with all your premise. We have to change the poor, by the way. They are not going to go into the streets anymore when there is a battle between two elite, right? So the solution really, over the long run, is to have a generation of leaders who know how it is to be poor. First, barangay. Second, 3 years more, municipalities. Third, 3 years more, provincial. And then after that, we will have this new generation and we will have a real democracy in this country and not just a fiction of it.
Mr. Chair, let me continue on. No? I'm so glad that Tony Monsod is already a prophet, telling us of what the future will hold. In reality, it cannot be so. This is real talk. For example, nabanggit ninyo, nung araw, number 1 tayo. Ngayon, huli na tayo. Ito, nagbago ba ang korupsyon? Hindi. Even the US today, a very powerful country, is dealing with corruption. Just the other week, a representative, a woman representative in Congress in the US, was arrested because she stole $5 million. Is that not corruption? In China, pinagmamalaki ng China, sila ay talagang mayaman. Kaya nga binubuli tayo dito eh. Hindi ba? Death penalty has been declared to an official in China. Let me tell you this, Attorney Monsod, whether we are rich or poor,
because human being is human being. Corruption will always be there. You see, the love of money will always be there. Now you're telling us about poverty. Nasaan po kayo? Ha? When Cory Aquino became president, and most of the poor people invaded Manila and Parañaque and Las Piñas and took over the coastal road. Anong pong ginawa ni President Fidel Ramos? Tinanggal niya yan. Anong ginawa ng next president? Anong nilagay doon? Casino. Casino. Bakit casino? Ha? In this country, whether we do not become very wealthy, yet, napakaraming lupa sa bansang ito na walang tao. Every Filipino family can have a piece of land and a building if they want to, Atty. Monsod. Now, you believe in checking poverty? What did the 1987 Constitution do to the poor? Nagbago ba ang poverty sa Pilipinas? Until now, 40% of our people are below the minimum wage line. Naniniwala ba kayo na mga ibang mahirap sa Pilipinas?
A lot of people do that. That's why I said in my talk na a lot of people blame the Constitution for the situation today.
Mr. Chair, I'm not blaming the Constitution. No, I'm not blaming the Constitution. I just said about the Constitution because you said that the 1987 Constitution does not need any revision. Samantalang narinig niyo ang sinabi ng mga resource speakers natin na maraming dapat na baguhin sa ating Constitution. Please take note, naniniwala din kayo dyan. You became a constitutional commissioner, that the basis of the laws of this land is the Constitution. And we are not referring to the people, we are referring to the laws of the land. This government is not ruled by the people, it is ruled by laws. Hindi po ba? Yun ang paniwala natin.
Well,
that will be the last question. So, Chairman Labante, please have an answer. Yes. After your answer, we'll recognize one of the authors to ask questions.
Can I just mention?
Congressman Panaligan.
Can I just mention something, sir?
Yes, please proceed, Chairman.
You know, I was the one who organized NAMFED against Marcos. And I was the one who organized Lente so that later lawyers can do that. I have been lawyering for farmers and urban poor for 38 years. I gave up going to business and so on. I've been, and these are my findings, sir, if you don't mind. My findings are this. The hope of this country is for us to elect from the poor, starting at the barangay, because that complies with the principle of solidarity, which relates to nationhood, and subsidiarity, that the power should be as close to the people as possible. Those, for example, promoting feudalism, you're creating an entire level of government at the regional level, which is farthest from the people. Now, so, my only point, my experience is this. I am a believer in the bureaucracy. I think there are many good people in the bureaucracy, and sometimes they're taken away, fed with corruption. This is my experience as chairman of the COMELEC. I was appointed because it was the first synchronized elections, and it would have, we were waiting for 25 years for a peaceful transfer of power. This is the elections of 1992. So I went around the provinces, and I told the people of COMELEC, you have a reputation of not knowing how to count, but I will not change any one of you. I worked exactly with the same people appointed during the Marcos time. And you know, I said, all I want from you is the gift of free, fair, and regular and credible elections in 1992, so we will have a peaceful transfer of power for the first time in 27 years. And they delivered. The people of Marcos delivered. Today, when I have problems, for example, with the goons of say San Miguel trying to build a tourism in Palawan, I could call some people I know at the PNP, so I did, and they called up. President Commander called, sir, what can I do? I said, get rid, please, of the goons who are always oppressing the indigenous peoples when they are not even armed. And it happened. It happened. Today we have a problem in Bugsuk. Why? Because Marcos in 1974 gave Bugsuk of 10,000 hectares to Landing Cojuangco, in exchange for 1,000 in Pangasinan and Tarlac, and that's a big problem. In Aquino in 2014 issued a notice of coverage for 5,000 of those properties. The present DAR reversed that decision, and we're fighting now. That's what we're against. But fortunately, there are good people and bad people in government, and the difference between good and bad, sir, is sometimes permeable in my experience. Good people do bad things. Bad people do good things. So we have together. We have to look for the people who can work.
Thank
with
you.
us.
Yeah. Thank you very much, Chairman. And before we proceed, let me just acknowledge the former Secretary General of the House of Representatives, Reggie Velasco. He's with us. Thank you for coming. Yeah. And now let me, before going to Congressman Panaligan, we have some words from our author and probably some questions. Deputy Speaker Ronnie Puno.
Just have some questions regarding the need for coming up with a competent convention if we are to have one. I address this question to Chairman Monsod. No? The 1987 Constitution was composed of very competent commissioners. I think that it is acknowledged that that assembly was one of the better assemblies, no, that have been convened in our country. This assembly was, I believe, appointed by the president. The prior constitutional conventions actually had delegates that were elected. So may I ask, Mr. Chairman, do you think that appointing members of a convention is advisable if we want to get really competent delegates to review our constitution?
Sorry.
The question is, would you recommend, would you agree that in the selection of delegates to in case you have a constitutional convention, that some may be appointed? That is the question. Because clearly there has to be elections, but there were also proposals this morning for some of the delegates to be appointed. What is your view on that?
I think, sir, that first of all, that there is no need for a constitutional convention today. I like the proposals of Congressman Puno, in which he says we should clean it up. Of course, we don't have a perfect constitution, and it's a good idea, right? One of them, of course, is the question of separate or joint vote in in the case of Section 1 of the amendments of the Constitution, we have already admitted that there was a fault on the part of the Constitutional Commission on this. However, there have been already talks since 10 or 14 years ago about this issue that was a mistake on the part of the Constitution. And those who still want to amend the Constitution, it's not necessary, because those of you in the House, have you read Section 145 of the rules of the House?
Mr. Chairman, may I put the question in a different way, no? Mr. Chairman, the members of the Constitutional Commission were appointed by President Aquino. That's correct, right? So my question, I guess, would be: do you believe that if a constitutional commission again were to be organized, that appointment is a better approach to bringing the members together than electing them?
Yeah, I think appointments would be okay. But I think my point is, you don't have to go into a convention now. That's my point. And
Yes, we understand that already, Mr. Chairman. I think that has been made very clear. But I just want to get the wisdom of the chairman, having been a member of the Constitutional Commission. And I think unlike the other bodies that reviewed the Constitution, this commission was completely appointed. So I just wanted to get a verification from Chairman Monsod whether he feels that this was the correct approach.
yeah, well,
Chairman Bonsod.
I have a little note here, for example. Of the 48 members of the Constitution, 6 were former senators, 5 were justices, 2 became chief justices. We had 3 Muslims. We have 1 from the indigenous people. We had 3 congressmen from the opposition. We have a Speaker of the House, Laurel. There were church people and evangelists. There were only 7 lawyers. There were 3 from media, 1 from cinema, Rhea Broca, 1 general from the Armed Forces of the Philippines, 2 economists, 3 on labor, and 2 educators. Certainly, there may be ways to appoint in order to complete the balance of the members of the commission. But please think about amendments to the Constitution, because that's the advice to us. For example, when there were when the experts were invited here in 2016, they said it's better if you already have a constitution to just amend or change the honest errors there, but to totally change the new and a new constitution is not a solution.
Thank you, Chairman. Now we'd like to recognize Congressman Panaligan for his comments.
Well, thank you, Mr. Chair. This is just a reaction to the interesting exchange between Congressman Abante and Chairman Monsod. So, Chairman Monsod said that there is no need to write a new constitution, only to amend or perhaps revise the constitution. Okay? Well, of course, we leave that to the wisdom of the Constitutional Convention. If ever a CONCON will be convened with the code, then the CONCON can either introduce amendments in certain provisions of the Constitution or revise some provisions or totally adopt a new charter, for the people. So, after all, that charter will be submitted to the people in a plebiscite. And since it's sovereignty resides in the people, then it's up to them if they want an entirely new constitution. Chairman Monsod also said that we should develop new leaders, young leaders, rather than discarding the present constitution. I agree with him. And I believe that we have seen in the past, especially from the ranks of local governments, we have promising leaders, no? Mayors, governors. But of course, it will take time, perhaps generations, to develop new leaders and to make them to be able to take over the entire government. It will take generations. No? So, but of course, our problems are urgent. Our problems now cry for immediate solutions. And also, even if we have young and promising leaders, bright leaders from the city halls, from the capitals, the question is, can they manage to win and national offices? Can they win in the Senate, for example? Can they win in other significant national positions, considering that I believe that our constitutional structures, our political system is not conducive for young leaders, but without privilege, without money, for example, without resources to gain political power. They may be brilliant, they may be promising, they may be people of integrity, but from our experience, they cannot win in the Senate, for example. It would be very difficult for them to win in a national election, national positions like the Senate, and of course, even in the presidency. So I believe that while there is a need, I agree that there is a need to develop young leaders, we should also see to it that our constitutional structures, our political system is conducive for the growth of these young leaders. And I believe that if there are provisions in the Constitution that should be revised, it's the political structures, not so much on the economic structures. Although I agree also that economic models should not be included in the Constitution, because economic models, economic trends, they change with the time. Our Constitution, 1970 Constitution, for example, 1930 Constitution, it was the said charters were formulated in an era of nationalism. No? That's why protectionist. No? But in the 1990s, 2000s, we saw the prevalence of the globalization, liberalization. Okay? But after the pandemic, we can discern a shift back to protectionism. No? So my point is that economic models should not be enshrined in the Constitution, because it will inhibit future policymakers. So they will not be able to respond to shifting trends in economics. For me personally, I'm in favor of nationalistic provisions of the Constitution. I believe in national industrialization. But I believe that it should not be enshrined in the Constitution. What we should revise are the political structures. Our political system is dysfunctional. So, kung meron man dapat baguhin is a system of government. And the fastest mode, of course, if only the people trust Congress, is Constituent Assembly. But that is next to impossible now. So, CONCON, perhaps, is the best mode to amend the Constitution.
Thank you, Congressman Panaligan. We go first to Dr. Rita Carlos and then to Chairman Nelson.
Thank you very much, Mr. Chairman. I would like to give some overview, listening to all the comments around the table. I think there is a need for a unity in the new constitution that will be drafted by whichever body. Why? Because a constitution will have to stitch together all the sections therein and will have to be governed or underpinned by a philosophy of governance. In other words, Mr. Chair, you cannot have sections that are colliding with each other because the philosophies are, they are colliding. And therefore, there must be a unity. I like what Congressman Panaligan said. You change the political structure and the rest of the substructures will follow. This is not, to denigrate economic provisions, I always say, as a political scientist, I know that it's the political really, which is the fulcrum of all political power. So when you change the Constitution, revision, you change the power configuration therein. But it must be stitched together. It must be crocheted by a philosophy of governance. Hindi pwedeng you're shooting here and there, tapos nagbubungguan siya. That's the reason why, and to the question of Congressman Puno kanina, siguro maganda rin yung i-appoint siya. No? I've never thought about it really. But the vetting procedure should be very strict. And because I'm a political scientist, I would lean more towards more political scientists in the commission. Why? Because a political scientist is trained in the tradition of science. In other words, however emotion you might put into your aspirations, your advocacies, data is king, which means whatever empirical evidence is there, then that should be followed. Say if the empirical evidence tells you that you don't need term limits, you don't need political dynasties, they are not the predictor variables. The predictor variables are somewhere else. So let's put science in all this. And I agree, Mr. Chair. The emotion is there, all right. But I think the science should also be there. Thank you.
Thank you, Dr. Carlos. So we now go to the last comment of the chairperson, and then we'll ask the members if they have more questions, and then we can probably call this a day. Yes, Chairman Mansad.
Sir, I just wanted to say that when we're talking about the Constitution, as if that's the solution. I think the solution is let us implement the Constitution. Now, when you, for example, talk about unless otherwise provided by law, it's a very dangerous proposal because it's a wholesale transfer of power from the Constitution to the Congress, for example, on foreign ownership. Once inserted, the constitutional provisions become meaningless, and the door is opened wider to transactional legislation, to which corrupt politicians and greedy business are very adept. The insertion is insidious because it is made to appear as a harmless, since it only gives Congress flexibility to determine the actual percentages at the appropriate time. But the change is made only by ordinary law, with much lesser House and Senate votes, and without need of a vote of the people in the plebiscite. Incidentally, in terms of numbers, when we talk about changes now in the Constitution, you need what? You need how many votes? About over 237 votes, 240 votes from the Senate, and how many? 70 or 18 from the Senate. With this insertion, you will need only about 80 congressmen and 7 senators, and that's what the people are suspicious about. Now, let me just close, sir, if I may. My first point is this: are we agreed on the ends? Because if we don't agree on the ends, then our means will not be the same. And if we agree on the ends, which is to have a new social order, in other words, a democracy that works, which, by the way, is not a partisan political purpose, are we willing to pay the price for it? Especially if it is against our own self-interest. Are we willing to make sacrifices for love of country and for the poor? Because we are told sacrifice is the currency of love. My second point: when the social contract between the government and the people may be breaking down, like today. The communities should take it among themselves to change the nature of the social contract. The pandemic, as I said before, had one big contribution to show us about the community.
Chairman, can you just wind up because we already heard about your transactional comments and so forth. So, yes.
I just want to give the example of Sinergia, where in 500 municipalities, where barangay captains are helping parents educate the children. My third point is already said that I think the poor should exercise their power. My fourth point, democracy is about dialogue and compromise, and I already mentioned that there are good.
Already mentioned that.
And our country is in need of heroes today. Not the super heroism of Gandhi or Nelson Mandela or Ninoy Aquino, but as ordinary everyday heroes, described by author Philip Zimbardo as, quote, the courage to expose fraud when we see it or to say no to complicity in wrongdoing, or by the hardness to be different or difficult to do what is right when it's easier to conform.
Thank you. Thank you, Chairman. So we take note of what you have stated. The others, we can submit that and will be put in our matrix. So with that,
Mr. Chair.
a final,
Mr. Chair, yes, I have one question.
first from the Congressman, and then we'll have Dr. Carlos.
I just would like to ask a question to Attorney Monsod. What he said a moment ago. Ang sabi niya kanina na hindi kinakailangan ng revision pero hindi kailangan ng bagong konstitusyon. Yun ang sabi niya. So I was wondering, sino mag-i-revise sa old constitution kung hindi ang Constitutional Convention? Sapagkat sabi niya, hindi kailangan ang Constitutional Convention. So ang tanong ko, sino mag-i-revise? Kung hindi kailangan ng new constitution, who will revise the old constitution? Napaka inamin niya eh. He admitted that the 1987 constitution needs some revisions. With that, pagkatapos yung sagot nito, I also would like to ask Justice Carpio what he thinks of the statement said a moment ago by Attorney Monson. Oo. Siya muna.
That question to our former associate, senior associate justice.
My question
What is the question
first.
to Justice Carpio?
My question first to Attorney Monson. If you do not believe that there should be a constitutional convention and that there is no need for a new constitution, but you believe the 1987 constitution must be revised, who will revise? Yun ang unang tanong ko kay Attorney Monson. And I would like also to ask that same question to Justice Carpio if he agrees with that.
But the question is, earlier, did you admit that there is a need to revise the Constitution? No or not? Is there a need to revise the Constitution or not?
There are changes that can be done. I like the proposal of Secretary of Congressman Puno. That there are things that can be done, but maybe not now, because now is not a bad place for that.
So there is a need, but not now. Thank you. So that is the position of Chairman Monson. We'll ask also now the same question. Is there a need to revise the Constitution? That is the question of our Congressman, Chairman Abante, to Justice Carpio.
Yes, Mr. Chair, my position is we should shift to a parliamentary system that requires revision. Thank you.
Thank you. So do you have, hey, last question from Congressman Panaligan.
Final point, Mr. Chair. I reiterate my stand that there is a need to review, whether to amend or revise or adopt a new charter. There is a need to review the present constitution. It has been 37 years, and I believe that Our experience in the past 37 years should have taught us already about the flaws, the defects, or the shortcomings or the inadequacies of the Constitution. We are not blaming the Charter for the present problem. No? Hindi po tayo misunderstand dyan. But a Charter is also a blueprint. No? Nakaka-apekto po yan eh. Whether sa politika, sa economics, in our social life, may epekto yung ating basic charter. So, we should review that. Disclosure, in 1992 or 91, I wrote an article in a law journal, no? Why we should not amend the 87 Constitution. But that was 1992, 5 years. At the time, the current charter was only 5 years old. So my point at that time was that let's give it a chance to work. No? But after 37 years, I think that now is the time to revise the present charter. Hindi po naman yan sagradong dokumento, hindi po yan gospel na hindi pwedeng baguhin ng mga tao. So now is the time, no, to amend the present charter. Sabi nga ni Roscoe Pound, the law must be stable but it cannot stand still. Kaya paano na po dapat ipag-usapan without emotionalism and sentimentalism.
Thank you very much, Congressman Aligan. For the last point, Dr. Carlos, and then we will thank everyone.
Just a very brief point. Counterintuitively, the term unless otherwise provided by law is really a channel for change. Why are we putting so much negative connotation to that phrase? When in fact, when you have a constitution, you are not able to foresee what the future looks like. Suppose you have an article there on generative AI. We don't know what the future looks like. So when you put a clause there, like unless provided by law, it's really a channel for recalibration, which you give to the legislature, whether it's unicameral or bicameral. So I don't think we should, treat that phrase so negatively, because it's really a channel for recalibration of the future. Thank you.
Thank you. So with that, we would therefore like to thank. I'll give Chairman Monsod one last point.
I just want to say,
It's a contrary position of Dr. Carlos. One last point.
I just want to say something. I think you can earn the trust of the people if you pass an anti-dynasty law and amend the party list system. If you do that, then you can do many things in changes in the Constitution.
Well noted. So on that note, we would like to thank all our resource persons. It has been very enlightening. We have the experts here and we have everyone. So thank you so much for your presence, and please submit your position papers so that it will be placed in the matrix. Thank you, my distinguished colleagues. Thank you, our valued resource persons. Thank you very much. Can you have a group picture? Yeah, for this batch. Thank you. You will go to the front for our picture taking. All right.